defense talked about, well, where's the gun? Must be two guns. State doesn't have either of those two guns. Where could he have put the gun? Can't see guns in the videos. You don't see guns on his person or where he could have hidden it. And those kind of represent these missing pieces of this image. You're right, I don't have the gun. I do not have the gun. I don't have all of his cell phone data because it was white. I don't have his IG because it was white. I don't have every single thing that I am mentioning at trial. I don't have the full thing. But can you tell what this is an image of with those missing pieces? Yes. It's still a dollar bill. So what I ask you to do, when we go back to that gas pump reference and using your common sense, you can make reasonable inferences from what I do have. Or unfortunately, when someone kills somebody, two people, and leaves the scene with the firearm, likelihood of getting that firearm back without apprehending them immediately, very low. So I don't have a firearm. But what I do have is a ton of witness statements. So I use this as an example that's similar to the gas pumps. I have a dog, and I also have a grandma. And one of these trials, I was working, my mom had to go out of town, and she left my grandma with me. She's in her 90s. So I was watching her, but if you ask my grandma, she was watching me. She didn't need to be watched. So I had grandma in the house, I have a dog in the house, and I went home, came home after work, had dinner with my grandma, and I needed to get back to court or get back to work to prep for trial. Every time I leave the house for an extended period of time, I always have like these little peanut butter cups. They're individually wrapped. Sometimes, every time I leave the house, I would give my dog one of the little peanut butter cups to keep him busy for a little bit. But my grandma's also used them for, her apples or carrots or whatever else. They're just individually wrapped peanut butter cups. So I, in a rush after dinner, took the peanut butter cups out of the cabinet, put it on the counter, opened one of them, gave it to the dog, ran out the house. When I got back at 2 o'clock in the morning, I had all these peanut butter cups all over the floor, through my kitchen and all the way leading up to the dog bed, right? They had been chewed on, they were pierced, and they were all empty, completely empty, wiped clean. I come back in, and usually when I walk in the door, dog runs up to me. He didn't this time. Odd, clue number one. I get to the kitchen and I'm seeing all of this, and there's only two possible scenarios. My dog went and got on the counter and pulled down the peanut butter cups and chewed open every single one of them and licked them clean. Or alternatively, my grandma just had it in her that day. And she said, I want to empty out all these peanut butter cups with just straight licking peanut butter, because the apples are still there, carrots are still there, and my grandma's upstairs asleep. And that late at night, she usually doesn't eat a whole bunch of peanut butter cups. I didn't see it. I was not there. I don't have a video of it. But I can make a reasonable inference of who cleaned out all those peanut butter cups, just based on the trail, based on the evidence that I had left. And that's what I'm asking you to do. We don't have a video of the murder, and we don't have someone saying, I saw him point the gun at his head and shoot. That's true. But you can make a reasonable inference based on the evidence that you do have. Who left the scene on foot? Who shot and killed another person on the way out? You got Ashbury, you got Rollo, and you got Tamika Myers. You got 3 witnesses that saw the right after effects of what happened after the bullet went in the back of his head. You know what? There's just so bad. Go to the slide. Go back. Okay. So I want to clarify some things. I went back, I read my notes, I looked at everybody's testimony statements, things like that. And I am not making the assumption or even conclusion that McCoy shot and killed Mr. Houston because he threw him in the pool. I'm not saying that that's what happened. What I'm saying is it was a buildup throughout the day. And the witness testimonies show that it was a buildup leading up to the murders. So while no one could give specific times, I used all of the details that they provided in their statements to kind of build on each other. The first would be Corey Dan Leonard. He got into an argument with McCoy at the party. That happened, and that's that inference of, or that's that thing of he tried him or he embarrassed him, disrespected him in front of women. That's that. That was the first start. And this is the argument. This is when the gun is taken off of him by security. Then you have Rollo Dukes that says security took the gun off of him at the party. And then he had another gun. So that's Rollo also being there in that moment saying there was a prior argument at the party about women and security took the gun off him. Tamika Myers says the same thing. Security took a gun off of him. She didn't know about, or she didn't testify about the argument. Rollo said there was an argument. And then the gun was taken off of him earlier in the day. Then next, you have Ashbury and his photos and his videos of the encounter with the bear hug and trying to pull Polo into the pool or Joshua Houston into the pool. That happened next based on the surrounding details of each person's statement. And the reason why I say that's next is because McCoy had just been thrown in the pool. He's glistening, he's wet, and now he's trying to throw Polo back into the pool, right? Then Miss Yasmin Bella Myers also mentions the pool thing. She doesn't know the whole context because she's not right there with Ashbury, but she does know that there was something going back and forth with him and Polo about the pool, right? And the reason I wasn't able to make that conclusion is, do you remember that video I played with another person capturing that moment? Not Ashbury, it was another Instagram account. And in the back of that Instagram account, you can hear him say, oh, that's the dude that they took, Debo took his shit off him or something like that. And I believe I said that with Detective Principe. And when you heard that, that means the gun's already been taken. There's already a previous encounter. So that's why Corey's encounter is first. Then you got Polo's encounter. And it's not really, I don't think, that deep, but it's just that continuation of laughing, you know, disrespect. He's already been disrespected, and now he's continuing to be disrespected. He feels he's being disrespected, and everybody's laughing, and everybody's posting it, like 4 different accounts. So that's the buildup. Then you have Flanell May with the keys. I heard you took my keys off me. Can I get my keys? Now, I put an asterisk by that because I don't know at what point he took the keys. But I do know he had to have given the keys back after he was thrown in the pool, likely so, because the keys are wet and now May can't open his car. So that's why I put an asterisk there. I feel like that falls right there, but it's somewhere in there. He took the keys, but he absolutely got the keys back after McCoy was thrown into the pool because they're wet and they're damaged and he can't go anywhere, so he's stuck at the property. Then you have Tamika Myers. If you remember in her testimony, she said they were all cleaning up and they were all getting ready to go. And McCoy came up to her and said, I didn't have to give your buddy his keys back. I didn't have to give your folks his keys back. Remember that? That means at that point, the keys are already back with May and he's still stuck there because the car doesn't work. But he's going to Tamika Myers to antagonize her and say, I didn't have to do that. I could have kept the keys. And she says, whatever, just go on. But at the time that he did that, they were cleaning up. So that means we're at nighttime, right? So then the next sequence of events would be Jametta Taylor. Remember, Jametta Taylor said he was talking about something. He just kept going on and on and on. And I said, if you got a problem with him, then just go talk to him. If y'all people like that, just go talk to him. And she said soon after that, she heard the shots. Sometime after that, she heard the shots, not long. And then you have Xavier Smith. Remember, he was there close by to the argument. He didn't see anything, but he said they were right there arguing. So that means he's left Jametta Taylor, right? And now he's going to talk to whoever he has a problem with, which is likely Dan from earlier. Same problem from earlier. He's talking to Dan, and Xavier says, Xavier Smith, in the report, his first name is incorrect. Xavier is his first name, and so it's Xavier Smith. I can't remember what Principe wrote in the report, but the last name is Smith, but the first name is Xavier. He says they were arguing about something. It was so stupid that I just walked off. Remember? So when you think about all their testimonies, it kind of follows a sequence of events in this order. That's the buildup. He walks off. And then the people that actually witnessed the murder would be Rollo Dukes, Tamika Myers, and Ashbury. Rollo Dukes is right there with the stupid argument that Smith is talking about. And at some point, they turn away to walk away. And that's when the shots are fired. He turns around. McCoy has a gun in his hands. And Dan, Corey Leonard, is on the ground bleeding. You just shot your man. So no, he didn't see the bullet actually go in his head, but he turns around right there in short distance enough to punch him in the mouth, that close. And he sees him with the gun in his hand, and he sees him laying on the ground. That's an eyewitness. Then you have Tamika Myers, who runs over there and observes him kicking the decedent. Observes him kicking. He ain't dead. Get up. He ain't dead. And then takes off running. And we can confirm this with your 911 calls. Who's right there at the 911 calls? All those voices you heard in the back. I had everybody identify themselves when they took the stand and identify who's behind them, who you hear in the back. You hear Rollo, he made a call. You hear Tamika Myers, she made a call. You also hear Jametta in the background, and you also hear Bella. Well, Ms. Myers said she couldn't confirm if that was her daughter's voice, but you hear at least Jametta in the background. And then Quinnell May, who said he went in the house because he didn't want to deal with this lunatic. I believe he called him a lunatic. He went in the house, but then he came out and he made a phone call. Or no, he went under the bed and made a phone call. That's right. So then Rollo Dukes actually observes him run off and shoot somebody else in the passenger of a vehicle. It says, then he shot that man. He ran off and shot that man. That confirms what Ashbury says, where he's on the driveway, gets shot, and then comes in, starts screaming, Polo's been shot, Polo's been shot, and runs around to the passenger side of the vehicle, screaming, telling everybody Polo's been shot, gets in the car and takes off to the hospital. That's how Rollo knows that. Because it exactly what Ashbury said. I'm on the driveway, I pull up, go up into the property, I get out, run around the passenger, scream out, Polo's been shot, Polo's been shot, and then get back in and drive off. So Ashbury says he actually saw McCoy. Again, didn't see that actual moment when he shot him in the chest, but he looked up, the dome light came on, he knew who he was seeing. He saw him when he was driving up with his lights. So he knew who was getting in the vehicle, but as soon as he said, we gotta go get Dan, Corey Leonard, that was that triggering moment. Literally triggering moment. And 2 more times he shoots. So that's 3 eyewitnesses to these 2 murders. Everyone else supports those witnesses with their statements. It all works in a sequence of events. I know I said yesterday that if you need to, if you want to watch Rollo's statement, I'm gonna save you some time. Because I believe, hopefully at this point, you've made up your mind on the decision of whether Mr. McCoy is guilty or innocent. But I believe that you have to go in the back and do your deliberations. But at this point, you have the evidence. But I'm gonna save you some time. I clipped it myself, and I also transcribed it last night. Dan said, this is gonna be the last time you pull a goddamn gun on me acting all stupid and shit. You can put the gun up and we can fight. We can just fight it. They grabbed him and took the gun from him. But this nigga had another gun. But then I got him, meaning Dan, and we walked off. It wasn't even, we had just turned around for 2 seconds, and then you hear pow. I didn't even pay attention to, but then cousin dropped. I turned around like, what the fuck wrong with you? The fuck? I turned around, cuz laying on the ground. I see blood coming out of his head. And then he, meaning Teasy, said, what's up? That nigga ain't dead. That nigga ain't dead. That goes with the same thing Tamika Myers said. He ain't dead. Then all you hear is 2 more shots. Pow, pow. And we jump up like, what the fuck? I go over and see blood in the car and then see the passenger in the car shot. That car that went to the hospital. You shot them folks in the car, bro. You literally went in and shot them folks. You literally know these people. We all folks. You shot them folks, bro. And then took off running out the gate. He's on foot. He can't go anywhere. He can't go nowhere out there. Ain't no telling where the fuck he's at now. It can't be nobody but him. I want you to hear that for yourself. It can't be nobody but him. And then the officer says, did you know what they were arguing about initially? He says, oh, it was some bullshit. Basically, he was saying, nigga, you tried me in front of a bitch. Word for word. I transcribed it, but don't believe me. I want you to listen to Rollo. And I clipped it for you to hear it. Battery might be dead.
had his rag around his head. Cause when he shot, it was more so on some me and his cousin walking off on some. Like, I'm telling you, like, bro, don't even worry about that shit. Y'all done had y'all, that's why that shit be ruled. All this shit broke down, everybody finna go home, bro. They just leave, man.
So, what were they arguing about?
He telling him, like, he telling the cousin, like, bro, like, oh, bro, this gonna be the last time you goddamn put a gun on me and act all stupid and shit, nigga. You put the gun up, nigga. We can just fight and nigga, we family. Whoop. So, one of the other partners, they ended up grabbing a nigga in the circuit and took the gun from him.
From
the shooter.
Okay.
Apparently, this nigga had another gun. Wow. So when they got to do it, and the cousin on some walk off shit, be on some, I got him. Just, I'm walking to your car. It wasn't even quick to turn around in 2 seconds. Like you heard, wow. I didn't pay attention to the cousin drop. I just heard the flower, and I turned around like, what the fuck wrong with you, nigga? Like, the fuck? I know you ain't, because I see the fire in your hand.
Right.
But when I turn around, your cousin laying on the ground. I brushed it, bro, what's up, bro? You got it, bro? Get up, bro. I see the blood come out of his head. I'm like, oh, hell no, bro. You just shot your cousin, bro. What the fuck is you on, bro? You tripping.
Right.
But what's up? Oh, that nigga ain't dead, on it. By that time, I don't punch him in the mouth. Pow! Like, nigga, you tripping, bro. The fuck? I'm hot now, like, bro, y'all come on, they get their gun off this nigga. You take off running. No well. By that time, we turn back around to go check on the cousin again, because he's like, I'm on his cousin, like, bro, wake up, bro. Like, wake up, bro. Talk to me, say something like, how many fingers I'm holding up on a medical system. So I'm sitting talking to him, but he's not responding. I'm checking his pulse, and bro, I'm not getting no pulse. I'm like, bro, he dead. So by this time, we was looking up. All you hear is 2 more shots. We jump up like, what the fuck? By that time, we run over here like, we see Buddy in the car like, bro, what the fuck, bro? I go over here, bro, you just shot the passenger in this car. But these folk won't get up and get that.
This car?
No, the car that went to the hospital.
Oh, okay.
You shot them folks in that car, bro. You literally walked in the phone and shot them folks, but they wouldn't get out the car and use the car, and you shot them. You know these people, bro. We all folks. You shot them folks, bro. And took off running out the gate. So when she came, we trying to tell her, like, baby, like, we just called y'all. Like, he's on foot. He can't go nowhere but out the gate, bro. Like, but in the midst of all, yeah, you trying to throw us in cuffs and all of this shit. We trying to tell you, like, baby, you just go out and get you a fucking feel, fuck around and probably ride past. They can catch him, just that simple. But as you can see, shit, we've been out here since 11 o'clock, bro. They don't tell her where the fuck he at now.
Right.
And we see her telling her, like, baby, y'all standing right here. I know y'all fucking shots going off. That these shots been going off since that nigga walked from this property. He can't be nobody but him. You him. But
you know what they were arguing about initially?
It was some bullshit. Basically on some he was saying, bitch, nigga, you tried me in front of a bitch and all this. And he's like, what are you talking about? Bro, you my cousin, bro. We finna get up out of here, bro. Fuck these hoes, bro. Every time they go, bro. Like, you tripping, bro. You drunk. Let's go.
Yeah.
No, fuck that. He's like, bro, you tripping, bro. You drunk, bro. Like, come on, bro. Like.
Now, I want to say the terminology or the use of words like, that's your bro, that's your cousin, that's folks, we folks. That's not meant as blood or familiar relationship. That is terminology that is used in culture. Sometimes in gang culture, sometimes in Black culture, but either way, those are not meant to say that is literally his cousin. You heard from his mom. Though he's not related to these people. So I don't want you to believe this is like some familial dispute. This is disrespect and the retaliation to disrespect. That's what this is. All day. But when I talk about my aims, antagonizing, aggressive, arrogant, and armed, All of these witness statements build up and show you exactly what he was that day. All of those things, which is like the worst combination.
Dip him! Dip him!
Stop,
Dip
bro.
him!
Jesus, stop being drunk.
Little ass nigga! Little ass nigga! Somebody, nigga! I'm not going nowhere, nigga! The biggest!
And unfortunately, he took his life. The last thing you see him recording is, "I'm not going nowhere." And what did McCoy say in response? "I'ma spare you on GD." He didn't do that. You can go to the next slide.
Dip him!
He left 2 families with a lifelong loss. And 2 people gone, life taken over senseless violence. It makes no sense. Dan literally was in the moment of helping him, not knowing what he just did. You need a ride? You good? Why are you walking out here? But unfortunately, he's just in the wrong place at the wrong time. And he said the wrong name. We just gotta go get Dan real quick, but we'll take you. And pow, pow, like Rolo said. Killing Polo to the right. Now, the defense said on closing that I brought witnesses here to entertain you. This was not entertainment. This was horrible. This was a horrible story. This was a horrible way for 2 people, 2 fathers with small children to leave, to go out. You ask the family, this wasn't entertainment. You may have had one little moment of Mr. Grimes being grown in the car, maybe, but the rest of this was not funny. But who was laughing? Who laughed throughout trial? I didn't laugh. Arrogant. Two young men, 2 young fathers who had their businesses, they were entrepreneurs, and we're not going to demonize them in any kind of way, calling them gang members. We had King and Manson on the stand, and she told you the criteria, what the 6-point criteria that she takes in concluding whether someone is a gang member or not. But again, that's pointless because it don't matter. Call them gang members. I won't. And King and Manson told you she doesn't just jump and call people gang members. Anthony McCoy has a history since 2018, consistently, and a huge tattoo on his back. And other things that she's considered in qualifying him as a gang member. But call them gang members if you want. It doesn't matter. It's still murder, and it's still disrespect that was retaliated with a killing. That doesn't matter. Him calling this a GD party, I'm glad it was stated, it is a GD party. But I played that video multiple times. Not everybody at that party was banging or on GD. Some people were just celebrating the 4th of July because it was a pool party. But there were gang members there because it was GD day. Again, what does that matter? It don't. He was celebrating GD day. They done let GDs in the door. McCoy, his actions, that's what matters. His state of mind at the time. So please don't get distracted by whether it was a GD party, where's the guns, these were gang members too. Did he do it or did he not do it? He did it. He killed these people. Now, yesterday, this part I want to clarify for you, and I did it a little different because I want to make sure that I get a guilty on every single count in my indictment. And so you've heard the facts this whole week, but you're being presented with the law for the first time. The judge is gonna read it to you, and then you're gonna have it in the back. But you have to, what I had to go to law school for, and I had to go to different gang trainings for, you have to do it, amongst yourselves. And so something that's more complicated, like a gang statute, I just want to simplify it in the best way to make sure we understand what is required and what's the nexus. You have to have a crime. McCoy committing the crime. Once you determine that he committed those crimes, then you have the top tier of the triangle. You don't have to even decide whether or not those crimes are those the crimes that make it criminal street gang activity. The law already tells you that. The judge will already tell you that. All these offenses that are pointed out meet the standard of criminal street gang activity. Check. Then, gangster disciples. Is it a gang? Based on the history, the structure, the identifiers, the huge tattoo on McCoy's back, does that exist? Or is he just really into the 4th of July, so he put that back there? Or does it exist? 6-pointed star, she gave you the whole history of it, how it was created and how it has come to Atlanta. She even mentioned a famous rapper, King Von, from Chicago. She said it started in Chicago, came down here. Guess where King Von died? In Atlanta. And he was GD. Anyways, is there a gang? Is Gangster Disciples a gang? And McCoy, is McCoy an associate of Gangster Disciples? Is there a connection between him and the gang? Is he associated with that gang? Yes, absolutely. He says it, he celebrates it for years, 2018 to now, what's that, 7 years at minimum. And he has a huge memorialized tattoo on his back. Yes, he is associated with the gang. Check. Now you can check all 3 of those. The next is that the participation of criminal street gang in furtherance of the gang. Is this the type of crime that is committed by the gang? Murder, aggravated assault, criminal damage to property. You heard from Manson. These are the types of crimes that are committed by the gang. So you'll see in the law proof that the crime was the sort of crime that the gang does. No, go back. Not simply a crime that a member of the gang may have committed in the past. And that's when I gave you something like a domestic dispute, right? Him being married and he shoots his wife and heat of passion. Now, domestic could also be in furtherance of the gang. So I'm not saying wipe out domestic, but that really doesn't apply here. Even if your wife disrespects you in front of people and you retaliate against her, I could create a nexus for that. But there are certain crimes, the way they are committed, that wouldn't be criminal street gang activity and wouldn't have the nexus, okay? But this isn't this case. So I just don't want you to confuse that with what you have to assess here. Proof that these crimes are the sort of crimes that the gang does. That's subsection A. That's count 1, right? Then count 2. You can switch. The maintain and increase status. I believe this is very straightforward as well. Crime, check. GD, check. McCoy, check. So all the same analysis. But did he do it in an effort to maintain and increase status? And Ms. Manson told you that when you are disrespected on a public scale the way he was, that must be addressed. That's a violation. Disrespect is everything. Respect is everything. And once you're disrespected in front of a woman here, but once you're disrespected on a scale like that, he has to respond. And that response, how public it was, what did Miss Meyer say? They felt haunted. They felt haunted. I believe somebody said lunatic. Like, yeah, y'all gonna remember me. Y'all gonna remember me. It was traumatic. Did it in front of everybody. Oh, they're gonna talk about it. They're gonna remember my name. That's to maintain and increase that status. So wherever he ends up, oh, I had a double homicide. In front of everybody. And that's on GD. So that's count 1 and count 2. I want to make sure that you understand both of those as you go back into the jury room and you deliberate whether Mr. McCoy is a member of a gang, the gang exists, and these crimes were done in furtherance of that gang. And come back with the verdict that makes the most sense, beyond a reasonable doubt. Remember, not a mathematics certainty, so 90%, none of that you heard in closing from the defense, but beyond a reasonable doubt. Come back with a guilty verdict on all the counts in the indictment. 2 counts of gang, 2 counts of malice murder, several counts of felony murder, 2 counts of aggravated assault, 1 count of criminal damage to property, 1 count of possession of a firearm during the commission of a felony, and 2 counts of possession of a firearm by a convicted felon. Thank you.
All right, members of the jury, it's now my duty to instruct you on the law that applies to this case, and that process takes about 15 to 20 minutes. Does anyone need a break, or do they want to get up and stretch a little bit? All right, we'll be back with you when we're ready. Okay, just let us know.
Battery is still.
All right, we'll be off the record until the jury is ready to resume.
Okay, just only be like 5 minutes. All right, folks, when the judge is charging the jury, nobody gonna be moved. And you gotta stay in. If you're gonna be out, you gotta stay out. Nobody gonna be moving. It's gonna be about 20 minutes. So if y'all wanna leave out, I figure y'all ain't gonna be able to stay in here. Y'all gotta leave out. Once y'all can't come in and out. Okay? All right.
Sure. It's just there. Have you ever seen, that's what argument, you ever seen? No. No. She's a gang. Well, yeah. Yeah.
You're allowed to meet the okay. Yep. Okay.
Oh, we can- And you're Western. It's hard.
Cell phone, please, if you don't, cell phone allowing this floor, even around this time, so if I see you with the cell phone, put you out, you gonna be able to return.
Excuse me, just one second. Deputy, do you have, Mr. Collins, do you have anybody up here? Nobody? Yeah. That means talking about.
That's just normal routine, but I guess I'm gonna have to get.
Yeah. He wants to multitask.
If we had to get them all together, we'd be late bringing it.
Okay.
But once this is done, then we'll have it.
Are they here though, you
They
think?
get in house.
Okay.
Who your guy?
All right, good deal. Thanks.
Wasn't even. All right, folks, once again, once the jury come back in and just start charging this jury, nobody can be moving. If y'all wanna go in, if y'all wanna go out, so you gotta stay out. If y'all stay in, I'll stay in. If y'all need to leave out, and they leave out now. Okay, but everybody's good? Everybody fine? Okay.
We have filed a motion. Predicate offenses, possession of firearm by convicted felon.
What county?
Here.
Mhm. I don't care.
This one, do you see it? Remember that one?
Oh, yeah. Why would it?
Yeah.
Maybe maybe he's gonna get charged. I don't know. Could be. I don't know.
Oh, he's gonna sue.
You already transcribed a lot of it, though.
I did,
Yeah.
because you wanted to.
I did. No. He might get charged federally as a criminal. You can get charged in both places.
Oh, really?
Yeah.
Oh.
I don't know what you want.
Hmm.
You're welcome. McAfee's.
Have you spoken to her?
No, didn't know she said that.
She asked.
I do. I've got it on the record. Yogi Bear. It is. He's very gracious though. Very.
What's up?
It needs to be a.
They're on another. They're in what?
The conference room. He's on my 5 minutes.
Can you check on them, Deputy Scott? They're ready? Well, bring them in. I don't know where the state went.
Jerry. Depends, Judge.
Thank you, Deputy Scott. We are back on the record. Mr. McCoy and his counsel are present. Deputy Scott, if you want to check in the hallway for the state. Members of the jury, as I advised you, now it's my obligation to charge you on the law that applies to this case. And so we begin. You are considering the case of the state of Georgia versus Anthony McCoy Jr. The grand jury has indicted the defendant with the offenses of violation of the Street Gang Terrorism and Prevention Act, 2 counts, murder, 2 counts, felony murder, 7 counts, aggravated assault with a deadly weapon, 2 counts, criminal damage to property in the 1st degree, possession of a firearm during the commission of a felony, and possession of a firearm by a convicted felon, 2 counts. You'll be provided with a copy of the indictment and these instructions during your deliberations. The defendant has entered a plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in his favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence presented. Then you must apply the law that I give you in this charge to the facts as you find them to be. Your oath requires that you will decide this case based upon the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses and any exhibits admitted during the trial. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. Direct evidence is that which may be seen or heard or otherwise directly sensed, such as by smell or taste or touch. It may be brought into court in the form of exhibits or the testimony of direct witnesses to such matters. It is evidence that points immediately to the issue in question. When direct evidence by inference points to an obvious, likely, or reasonable conclusion, even though that conclusion was not directly seen, heard, smelled, tasted, or touched, that is said to be circumstantial or indirect evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in light of your experience. It is evidence that only tends to establish a conclusion in question by its consistency with such conclusion or elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on circumstantial evidence, the proved facts must not only be consistent with the theory of guilt, but also exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher or greater degree of certainty on the part of the jury to return a verdict based upon circumstantial evidence than upon direct evidence. Whether dependent upon direct or circumstantial evidence, or both, the true test is whether there is sufficient evidence or whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit. If so, you may convict. There is no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for you, the jury, to decide. The jury must determine the credibility of the witnesses. In deciding this, you may consider all of the facts and circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. The credibility of a witness may be attacked by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. The defendant does not have to present any evidence nor testify. If the defendant chooses not to testify, you may not consider that in any way in making your decision. Sometimes evidence is admitted for a limited purpose. Such evidence may be considered by the jury for the sole issue or purpose for which the evidence is limited and not for any other purpose. Identity is a question of fact for you to determine. Your determination of identity is dependent upon the credibility of the witness or witnesses offered for that purpose. You should consider all of the factors previously charged you regarding credibility of witnesses. Some, but not all of the factors you may consider in assessing reliability of identification are: 1, the opportunity of the witness to view the alleged perpetrator at the time of the alleged incident; 2, the witness's degree of attention towards the alleged perpetrator at the time of the alleged incident; 3, the possibility of mistaken identity; 4, whether the witness's identification may have been influenced by factors other than the view that the witness claimed to have; 5, whether the witness on any prior occasion did not identify the defendant in this case as the alleged perpetrator; and 6, the length of time between the crime and the out-of-court identification. It is for you to say whether, under the evidence in this case, the testimony of the witnesses, and the facts and circumstances of the case, sufficiently identify this defendant beyond a reasonable doubt as the perpetrator of the alleged crime. It is not necessary that the defendant show that another person committed the alleged offense. If you do not believe that the defendant has been sufficiently identified as the person who committed the alleged crime, or if you have any reasonable doubt about such, then it would be your duty to acquit the defendant. The burden of proof rests upon the state to prove beyond a reasonable doubt the identity of this defendant as the person who committed the crime alleged in this bill of indictment. The defendant is charged with a crime against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of an act and intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be, in your discretion, inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. This defendant will not be presumed to have acted with criminal intent, but you may find such intention, or the absence of it, upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. The defendant is charged with the offense of violation of the Street Gang Terrorism and Prevention Act. As alleged in count 1, a person commits the offense of violation of the Street Gang Terrorism Prevention Act when that person, while employed by or associated with a criminal street gang, participates in criminal gang activity through the commission of any criminal offense in the state of Georgia that constitutes criminal gang activity. In order to prove this violation of the Street Gang Terrorism and Prevention Act, the state must prove beyond a reasonable doubt 4 elements. First, the state must prove that there is a criminal street gang. Under Georgia law, a criminal street gang means any organization, association, or group of 3 or more persons associated in fact, whether formal or informal, which engages in criminal gang activity. The term criminal street gang shall not include 3 or more persons associated in fact, whether formal or informal, who are not engaged in criminal gang activity. The existence of a criminal street gang may be established by evidence of a common name or common identifying signs, symbols, tattoos, graffiti, or attire or other distinguishing characteristics, including but not limited to common activities, customs, or behaviors. The commission of any offense that would constitute criminal gang activity by any member or associate of an alleged criminal street gang may be considered by you to determine whether the state has proven beyond a reasonable doubt the existence of the criminal street gang and criminal gang activity. Whether a criminal street gang exists in this case is for you, the jury, to decide. Second, the state must prove that the defendant is associated with that criminal street gang. It is not necessary, though, that the state prove that the defendant is a member of that gang. Third, the state must prove that the defendant conducted or participated in the alleged predicate act. Criminal gang activity includes the commission of any criminal offense in the state of Georgia that involves violence, possession of a weapon, or use of a weapon. As charged in this case, criminal gang activity includes murder, felony murder, aggravated assault with a deadly weapon, criminal damage to property in the first degree, possession of a firearm during the commission of a felony, and possession of a firearm by a convicted felon. Lastly, the state must prove that there is a nexus between the crime committed and the gang, that the crime was committed to further the interests of the gang, meaning proof that the crime committed was the sort of crime that the gang does, not simply a crime that a member of the gang may have committed in the past. As alleged at count 2, a person commits the offense of violation of the Street Gang Terrorism and Prevention Act when that person, while in a criminal street gang, commits a criminal offense in the state of Georgia that constitutes gang activity with the intent to maintain or increase his status in the criminal street gang. For malice murder, the state must prove that the defendant, 1, caused the death of another person, 2, unlawfully, and 3, with malice aforethought. The killing must have been done with malice to be murder. Malice, as that term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, that is enough for the killing to be murder. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. For felony murder, the state must prove that the defendant, 1, caused the death of another person, 2, by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Aggravated assault with a deadly weapon, criminal damage to property in the first degree, and possession of a firearm by a convicted felon are felonies, which I'll define for you shortly. You may find the defendant guilty of felony murder if you believe that he caused the death of another person by committing the felony of aggravated assault with a deadly weapon, criminal damage to property in the first degree, or possession of a firearm by a convicted felon, regardless of whether he intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. For aggravated assault, the state must prove that the defendant, 1, assaulted another person, 2, with a deadly weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person or committed an act that placed the person in reasonable apprehension or fear of immediately receiving a violent injury. A firearm, when used in the way a firearm is ordinarily used, is a deadly weapon. A person commits the offense of criminal damage to property in the first degree when he knowingly and without authority interferes with any property in a manner so as to endanger human life. For possession of a firearm during the commission of a felony, the state must prove that the defendant, 1, has a firearm, 2, on his person and within arm's reach of his person, 3, while committing a felony, which is a crime against or involving another person. Murder, felony murder, and aggravated assault with a deadly weapon and criminal damage to property in the first degree are felonies. The term firearm includes any handgun. For possession of a firearm by a convicted felon as alleged in count 16, the state must prove the defendant, 1, possessed a firearm, 2, after having been convicted of a felony. And for possession of a firearm by a convicted felon as alleged in count 17, the defendant must prove that the defendant, 1, possessed a firearm, 2, after having been convicted of a felony involving the possession of a firearm. The law provides that criminal actions shall be tried and indicted in the county in which the crime was committed. Venue, that is, that the crime was committed in Fulton County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offenses. Venue must be proved by direct or circumstantial evidence, or both. By no ruling or comment that I have made during the progress of this trial have I intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendant. Your verdict in this case should be a true verdict, based upon your opinion of the evidence according to the laws given to you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively, without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, or economic status for or against either party. You are only concerned with whether the defendant is guilty or not guilty. You are not to concern yourselves with punishment. One of your first duties in the jury room will be to choose one of you to be the foreperson. The foreperson will manage your deliberations and will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Talk with each other and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case with your fellow jurors. Do not hesitate to change an opinion if you are convinced that it is wrong. However, you should never give up an honest opinion to be congenial or to reach a verdict solely because of the opinions of the other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are also not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. These rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, blogs, or social media of any kind. Whatever your verdict is, it must be unanimous. That is agreed to by all. The verdict must be in writing and signed by one of your members as foreperson, dated, and returned to be published here in open court. Do not begin your deliberations until you receive the indictment and any evidence that has been admitted in this case, and then you may begin your deliberations. Beginning with the state, any objection to the charge?
Your Honor.
And for the defense?
No, Your Honor.
Members of the jury, in just a moment, I'll excuse you to the jury room. As I mentioned, it's going to take us a few minutes here to compile the exhibits to give to you. We'll also have the indictment, and we'll also have a prepared verdict form listing each of these counts and where you're to mark guilty or not guilty for each offense, which you can then sign and date. And so at this time, I would ask you all to retire to the jury room with the exception of juror 45, if you could stay behind with us. Thank you, Deputy Scott. All right, juror 45, you might have gathered you are our alternate, our last one. And so that doesn't mean you're off the hook just yet. We have had occasions before where we need to sub in an alternate, even in the middle of deliberations, or if deliberations stretch into next week or we lose somebody, something like that. So what I want to do at this time is excuse you for the day. You can wait if you want to wait around for lunch, which I told you we were bringing around 11. But if you'd rather just leave, that's perfectly fine. Deputy Scott will help retrieve your belongings. But you'll still be under the obligations of your juror oath, which means not to research the case, not to do any research. And then if this jury is able to reach a verdict today, we're going to call you and let you know you're completely done. But until you get that call, just realize that we may have to bring you back. And we'll give you an update later today on where we are with that. So if we don't see you again, I want to thank you again so much for the time you invested in this case, your attention throughout it, and we'll see you next time. Thank you. All right, counsel, we'll go off the record here shortly so we can start talking about what goes in, what goes back, if there are any objections to what goes in, what goes back, and proceed from there. So let's go off the record for a moment. And I did have I'd left I think the verdict form and a copy of the charge up here yesterday. Do we still have that? All right. Do we have a clean copy of the indictment available? Does anyone have one? We can print one off if not. And then state have a stack of exhibits.
Yes.
We're going to start going through those, and then you can confer with Mr. Cowan if there are any disagreements. Ms. Smith, I give you Court's Exhibit 1 back. I can print one.
Oh, she's not, she's pregnant.
Probably. Yeah, we'll do it all here. You're not going anywhere. No.
She started with it today, so. Aggressiveness.
Ms. Vortis, did we have someone joining us on Zoom at 10 o'clock for a change of plea? Go back and ask. Perfect. Okay. I think we might have had somebody.
We do, Judge.
So, sorry.
Okay. Let me step off and make sure I get that calendar uploaded. Yeah, but I think you start adding people.
This. Yeah. We don't need to. This is extras. This.
Not.
I think that's done. You got. Just take that off. But. Should make sure everything go wire. It's in that little room, make sure everything is. I stashed away somewhere. Well, I do, it's in the closet, but I didn't. Okay. Yeah. Take this off. Wait.
Third party that exists. And I just want to think about.
Yeah. Oh. And this is 7. Or 7. Yeah. This is. Even. Two. See?
I hope the jury.
You might want to do yesterday. It's in the. Start pulling out the videos. Let's make sure she has all those. So it would be Kelvin Thomas, Exhibit 8.
Are they getting these flashbacks?
Yes. So,
So 8.
We will.
We're gonna
I'm gonna
give
see if
them
they can get their exhibits in order, and then we gotta switch over to the
that's
plea calendar.
9.
Hold on for please.
So all the way.
Covered that already. Yeah, I know. Stick around.
All right, where are we at with exhibits?
I'm just making sure they're in order, Judge,
All right.
and give them to the defense. I pulled out what I believe is,
Not yet. No.
shouldn't go back.
Okay, good. I'll
Making
take
sure they're
that.
in order.
No more in here.
What you missing?
Nothing. I was just like,
I got the,
Those are-
yeah, I got that.
Oh, here's the stack. I was trying to put them in order. Huh?
And, I guess we can transition all the attorneys.
Oh, I don't. I went all the way to 500, but I skipped some. Yeah.
who's the?
That one time. That one time, yeah. I have like a Basenji, do you know, with the curly tail, but he's like mixed with other things.
Those are the best kind.
Yeah. So,
This freight might be in, so I'll put it high.
do you have a problem with the business record cert, CADs? I took the gang PowerPoint out because that wouldn't go back. And I took out the. I think there's something else I took out.
I think they're gonna be asking.
The certified convictions, I don't think they're gonna ask to see videos, but I have them here.
You took some right here. She's out.
They're right here. They go out. We can ask the court. Your Honor, certified convictions?
Is that something you're all in agreement on, or what's?
No, we're asking the court.
I mean, I'll look at my cheat sheet here offhand. I think they go back as the documentary.
Yeah.
Unless there might be something to redact on there, like the sentences received. If you want to get to the world of redactions.
Oh, but I don't know how to, it's
Yeah.
attached. It's all,
Scan them and black them out.
like, the conviction has the sentence. It's attached.
Right.
It's Pendleton ADA.
Yeah.
I think the only thing we're agreeing on is the gang PowerPoint doesn't go back. I know, I took out the extras.
All right, prior convictions should be redacted to remove sentencing information relating to the length, any matters going beyond the fact that the crime is a felony and that the defendant was convicted.
So should I make a copy of it with the? Okay, all right.
But for now, if you'd like, if it's with agreement of both parties, we can send back what you do agree on and you can work on those redacted copies while they begin
Okay,
their deliberations.
all right.
If that's with,
Let me do that.
we're gonna
Okay.
put all this on the record in a minute here. Let's finish all the other exhibits first and send back what we do have.
We're done. Here you go.
Okay.
Done. And then those are the videos?
Yep, and they're in order. Yeah.
And I'm not losing.
What is that? Oh. Never seen a ring like that.
Well, I just keep losing.
Yeah, that's smart.
This is my way of pumping it.
You ready? Can we do this a little bit first?
Yeah.
Okay.
I was gonna get all these for, I need all.
Oh, let's just get the record part over with. All right, we are back on the record. All parties and counsel are present. And I believe the council have conferred on which exhibits go back with the jury. And we've got a stack of exhibits on top of which I'll place the indictment, the agreed upon verdict form, and what I've marked as Court's Exhibit 2, which is the final charge. And the only point of clarification between the parties was that was raised to me is the certified convictions. And as I understand it, the state is going to be working on redacting any sentence that's indicated on those convictions. And so and we're going to let the jury begin their deliberations without those, and we'll provide those later on this morning. And so, first of all, is there any objection to that procedure, Mr. Cowan?
No, Your Honor, this time.
And then is there anything else in this stack of exhibits that we're going to send back, or anything else that you would like, you have an objection to, or anything that needs to be clarified on the record?
I don't, Judge.
Anything, Ms. Green? All right, then we will hand all this to Deputy Scott, and deliberations will begin at approximately 10:30.
This is what's not. Bring this back to you. I don't know.
Ms. Forrest.
All right. And we are off the record.
I'm gonna give it to you.
It is the ring and all of that. It would be easy. What? Can I keep the?
I'm just. I just brought my.
Make sure I take. I just do that.
I'll take it.
I need to open it up.
You know, I may have it with me though. Maybe in the car. I'll have to go look.
I will ask this question. Hey, good morning. How are you? Good.
You know, I can if I can do this.
Right. That would be fine. I could do that electronically. Yeah. But the originals, you just have my.
Okay, well, that's better. Okay, wait. I mean, I'm sad about it,
Are
but
these
it's better
copies?
for you, I guess.
Okay, may I hang on to these?
They're not attached to the indictment.
That's okay. All right.
It usually has the indictment in fact. I got a project for you. I'm sorry? Okay, but it's coming back. The ring and all those exhibits are gotta come back,
Thank you
right?
much.
Yeah.
Misha, you need to step off again.
I would have been spring. I don't think it's gonna get a month.
Deputy Scott
So
can
we
do
got a
that.
little.
We got a plea to
project
take.
work on.
So we're going to switch over to the plea calendar, O'Reilly.
What was it? Oh, yeah. Gotta have the back. Sure.
I don't know. I just heard Riley was the one. that stuff.
No problem. I mean, Riley, not me.
Yeah, that's the one.
Can you help her find the jury packets? I kept them in here.
All right. Mr. McCoy can wait in the back.
This is.
Do you remember where you put them?
As a list.
Don't worry about it.
Yes.
Right there?
Yes.
Switching over to O'Reilly. They're all on.
They're all.
Anytime not logged in? You give him a call?
Ms. Ortiz, I'm gonna go back to my office. I might have pulled it out.
Okay.
Work on the redactions. I'll stay here.
Yeah, I was gonna hang it.
We haven't updated our calendar yet. Yes, so. Oh, no, we haven't started the training.
Join. Yeah, that's text goes on.
Okay.
Yeah. Can't burglarize in this.
Okay,
It's a theft.
okay, let me look it up. I'll have to look into that.
Yes, yeah.
You gonna do it? Okay. Was she supposed to have been assigned like a week ago?
The defense center.
You just can't escape, Miss Rutland.
No, how exciting.
Funny how that works, isn't it? All right, so apparently you're covering for Mr. Pennington?
Yes, yes.
All right.
Yes.
You don't have an offer.
Let me just check in with our folks on Zoom for Mr. O'Reilly. See who we have with us. If you could go
Judge,
off mute and on screen.
Judge, both Mr. Riley and I are present on Zoom. He is ready to enter a plea.
All right, welcome, Mr. Smith. Let me make sure I can see Mr. Riley. There he is. And I think Ms. Rutland's here on behalf of the state, so I can see that fine. Yeah. So just give us another minute here and we'll be ready to go on the record soon.
Sounds good.
Ready? Ms. Rutland, are you ready?
I'm ready.
All right. We are on the record now with 23 SC 189529 State versus Paul O'Reilly. And myself and the state are here in court, and Mr. O'Reilly and his counsel, Mr. Scott Smith, are joining us by Zoom. And this is an add-on to today's calendar for a change of plea. Let me begin, Mr. Smith, by asking any objections to proceeding in this mixed virtual capacity?
No, Judge.
Do we have permission to sign the indictment on behalf of you and your client indicating the change of plea?
Yes.
All right. And Mr. O'Reilly, if at any point you want to meet or confer with your attorney privately to pause the proceedings, or you can't hear anything we say, if there's a glitch of any kind, feel free to speak up and let us know, okay?
Okay.
All right. Ms. Rutland?
Mr. O'Reilly, will you please raise your right hand? Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
I swear.
Thank you. You may lower your hand. Will you please state your true, correct, and legal name?
Paul David O'Reilly.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there any medication that you normally take that you have not been given today?
No.
How old are you and how far have you gone in school?
I am 46 years old and I have a bachelor's degree. I have completed some master's courses.
Okay, are you able to read, write, and understand the English language?
Yes, I am.
Do you understand that you are charged with cruelty to children in the first degree? That charge has been reduced to family violence battery misdemeanor under OCGA 16-5-23.1, subsection F2A. Do you understand?
Yes, I understand.
And do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you can have a jury trial?
Yes, I understand.
Have you had enough time to speak with your lawyer, Mr. Smith, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, I have.
Do you need any additional time to discuss the case with your attorney?
No, I don't.
Are you satisfied with his services?
Yes.
Counsel, are you satisfied your client has a full understanding of this proceeding?
I am.
And do you waive formal reading of the indictment?
I do.
Do you waive any and all defects in the indictment for purposes of this plea?
I do.
Mr. O'Reilly, have you been arrested on these charges?
Yes,
Okay, the state is unaware of any outstanding warrants related to these charges.
I should say he does have an FTA, but I think that this would resolve it. Just ask the court to issue an order, making sure that the failure to appear warrant is lifted.
It'll be noted in the final disposition, lifting any warrants. Ms. Rutland?
Okay, Mr. O'Reilly, has your attorney advised you of the minimum and maximum, which is 1 day to 12 months in custody for the charge you're pleading to?
yes,
And do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 12 months probation? You'll also be subject to special conditions, including you are required to complete a family violence intervention program. You are to have no violent contact with Azraya, Aasryah O'Reilly, and you may report by phone. And once the family violence intervention program is complete, you may be, the probation may become non-reporting. Do you understand?
I understand.
Are you aware that the court does not have to accept that recommendation and the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after another?
I understand.
Do you understand that if you do not accept the court sentence, you may withdraw your plea?
I understand.
Do you understand that you may not withdraw your guilty plea if the court orders a sentence other than your counsel's recommendation?
I understand.
And do you understand that you have until the end of this term of court to file a motion to withdraw your guilty plea?
I understand.
And do you understand that if you chose to file a motion to withdraw your plea, the discretion to grant that motion lies within the discretion of the court?
I understand.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
I understand.
Do you understand the general conditions of probation?
I understand.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
I understood that there was an option to request that it is, I don't know the legal term.
Sealed,
Uh,
probably.
Is he using first offender?
He is, Judge.
Okay.
Okay.
Mr. Riley, what you're saying is correct. Thank you for interrupting. Basically, the state is saying that you're entering a guilty plea. It will be on your permanent record. However, you're entering the First Offender Act, which means the judge will put aside your conviction. As long as you successfully complete the terms and conditions of your probation without any violations, the judge will issue an order discharging you under Georgia law.
I understand.
Do you understand that if you are charged with a crime in the future, this plea may be used to enhance sentencing, including on a federal case?
I understand.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
I understand.
Do you understand that if you are not a United States citizen, a guilty plea will affect your immigration status and will result in deportation, just like a conviction at trial would, and that this is true regardless of any advice by your attorney or anyone else?
I understand.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand?
I understand.
And do you understand that by pleading guilty, excuse me. Let's see. Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes, I am.
Have you ever pleaded guilty or nolo contendere to or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No, I have not.
Have you ever been sentenced for any crime, felony or misdemeanor under the First Offender Act?
No, I have not.
Has your lawyer explained the First Offender Act to you?
Yes, he has.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for each charge in this indictment?
Yes, I do.
Do you understand that the federal government considers a first offender plea a conviction for the purpose of deportation and it can still affect your ability to remain?
Yes, I do.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
I understand.
Do you understand that by pleading guilty, you're giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses against you and to question them, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove you are guilty of each charge beyond a reasonable doubt, the right to testify on your own behalf or remain silent, and the jury would be told they could not use your choice against you, the right to present other evidence of your own and call your own witnesses if you chose to, and the right to appeal if convicted of these charges after a trial. Do you understand?
I understand.
Counsel, are you satisfied your client understands these rights they'll be waiving by pleading to the charge?
Yes, ma'am.
Mr. O'Reilly, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, they have not.
Is it your decision to waive the rights we just talked about and enter a guilty plea because you are in fact guilty?
Yes, it is.
As to indictment 23 SC 189529, how do you plead?
I plead guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes, it is.
Do you understand that you have 30 days in which to appeal your conviction based on your plea today?
Yes, I do.
Do you understand that you have until the end of this term of court or 30 days, whichever is later, to move to withdraw your plea?
Yes, I do.
And do you understand that you have 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, I do.
Thank you. And
Thank you.
counsel, I believe the state and defense have stipulated to a factual basis.
You can just outline any reason for the reduction position of the victim.
She has had no contact with her father since the incident and wishes to move on with her life. Her wish was for him to take accountability, but she was not looking for him to have severe consequences. Thus, the offer to resolve was a misdemeanor.
All right, thank you, Ms. Rutland. Did we have anyone from probation joining us on Zoom? Oh, there you are, Ms. Acusa. You're directly behind Ms. Rutland. So I want to confirm, because I think I might have this mixed up, because this has come up before, the remote phone-in reporting. Is that something that he can do?
Was it
But this is a misdemeanor supervision.
misdemeanor? I don't know.
Okay,
But I believe people have done phone in for misdemeanor, but I'm not sure their rules.
we'll leave it at that. Mr. Smith, anything else I should know?
Thank you for bringing that up, Judge. I think maybe just mention in the order that mail and phone in okay. What should happen is, I guess I'll get Ms. Vortis to help fill out the misdemeanor information. And then I think the onus is now on Mr. O'Reilly. I think felony probation could correct me, but the onus on Mr. O'Reilly to email them and say, hey, this is my contact information. That's the form I've been seeing in state court in the last couple of times I've appeared in Fulton. The second thing I do want to bring to the court's attention is the FVIP program, Family Violence Intervention Program, is generally an in-person program. I just ask that the order reflect that he is permitted to do that virtually because he is a resident out of the country and lives in Abu Dhabi.
Is that even an option?
It is.
Okay.
It is. Georgia FVIP is not, but if you just put in there that they can attend a family violence intervention program virtually, I think that would satisfy.
Okay.
Honestly, it's a very onus program in the sense that it's a 24 session program. I don't know if you want to get that much into the weeds with it to say minimum of 24 sessions. It's up to the court.
I'll note that he has to complete FVIP or a comparable program and that it can be done virtually. All right, so Mr. O'Reilly, do you understand the nature of this charge?
Yes, Your Honor.
Still wish to waive all the rights that were explained to you and proceed with this change of plea?
Yes, Your Honor.
And that's because you committed this offense.
Yes, Your Honor.
Do you have a weapons carry license of any kind?
I have a carry license in Georgia, no weapons.
Do you know what county that weapons carry license is with?
Fulton County.
All right. So I believe I'm obligated to inform our probate judge of that, and that license may be revoked as a result of this sentence. I believe you would be able to reapply after you successfully complete it. And so, Mr. Smith, are you satisfied your client is competent, that the plea is voluntary and intelligent, and that there is a sufficient factual basis?
Yes, Judge.
All right, I agree. I'll make those same findings, and I will approve the recommendation of the parties. I'll withhold adjudication, sentencing you under the First Offender Act, Mr. O'Reilly, to 12 months probation. Special conditions here are you're to complete a family violence intervention program or a comparable program, which can be done virtually. You'd have no violent contact with the listed victim in this indictment, and your probation may have remote phone-in reporting. Also, is there any objection to the sealing request, Ms. Rutland?
No objection.
Then I will impose that as well, finding that your privacy interests outweigh any public concern of this case. Anything further for the record on behalf of the state?
Nothing further.
Anything else, Mr. Smith?
It's good to see you, Judge.
You as well. And so, Mr. O'Reilly, I believe your attorney is going to be following up with our courtroom staff here to make sure that we have your contact information. And whether it's your obligation to reach out or whether misdemeanor probation is going to be reaching out to you, the expectation is that there will be some communication. So I'll direct you to be proactive about that in the next couple of days, okay?
I will be. Thank you, Judge.
All right. Then if there's nothing else, we'll be off the record. Take care.
Thank you, Judge. Good to see you.
He did say Abu Dhabi.
Thank you.
Let's hear for Gerald. She gets them. All righty, let me check in. Deputy Scott, were we able to get everyone transported up?
I'm going to get them ready. So if you give me a minute, I'm gonna help her bring them up.
We don't have anybody up yet, though? Okay. All right. We'll be in recess. Good morning, y'all.
Good morning. I know Mr. Harvey, his mother is here, Jaquez Harvey, and she was wondering if Mr.
Mitchell's coming?
Mr. Mitchell's coming. She's kind of small.
I don't know. Let me ask.
But she is
He
here.
is not coming. He has a leave for today.
There you go. So did we get waivers from him?
No, and he hasn't filed an entry.
Yeah, so we're gonna have to
On it.
reset those.
Yes.
Yeah, there you have it. So ma'am, assigned attorney couldn't make it today. And so we're gonna have to set up for another arraignment and to make sure that he files an entry and we have an announcement. Yes, ma'am.
A couple weeks ago, they said it was a carpenter entry because Mr. Mitchell was representing his co-defendant, but now.
Is the other way around. The folks here were representing the co-defendant. So now we have found an attorney who doesn't have a conflict of interest. And that's Mr. Mitchell, as I understand it. I don't know what you mean. Mr. Mitchell? I don't know. I don't think he's a junior. No. Yeah. Is it a junior? Oh, I didn't know that. All right. He may have just had the names mixed up. We'll check with him. But this is why we'll have another arraignment so that we know for certain before Mr. Mitchell files that entry of appearance. They should. They should. All right. All right, let me step off.
Oh, you did? Yes.
I don't know yet. We haven't talked to this.
Oh, most of them are in custody. Okay.
Everybody's in custody.
Oh,
except for
everyone.
Oh,
So-
okay.
Oh.
What?
No, everyone's in custody. We told her everybody was in custody and she went. I'm gonna have to say stuff.
What, Griffin, yeah, leaving, I'm sorry.
No, I mean, it's like everything.
That's what I'm saying.
It's good. Still morning. It's good.
Miss Well?
No, she's just going.
She's just going to a different. Oh, you mean leaving, period.
Or else I would.
I'm not just leaving.
I'm just going to a different.
Yeah.
No, she's not
I was
leaving.
like, you just got here.
That's what I said. I was like, I'm just going to a different one. She's still with us.
So who's gonna replace you?
Yeah.
Christina Clark.
I don't know. I don't think she's been assigned to this courtroom.
And Miss Rutland's leaving, sis?
I know.
know.
Just like
Maybe.
as soon as you get
For real.
comfortable, then you get uncomfortable. And then you get comfortable and it's like, well, we don't do that in our office. I just want to know. Yeah, because Attorney Sim have been here.
Well, don't jinx it. Don't jinx.
Don't jinx it. Oh, he's not going nowhere.
I hope not.
Knock on wood.
Right.
I've been here longer than Judge McAfee
Yeah.
on this stuff.
Oh, wow.
Really?
Yeah.
You have?
I was here when Glanville was.
Oh,
wow.
wow. Together. Oh,
Yeah, that's
there's
right.
no way
Yeah.
here together.
That's the old man of the courtroom.
Kind of, yeah.
That's all the time.
Feels
you
like
can
it.
take- That's the only time you can take old man. and do it.
Yeah.
Wow.
You're a baby.
Look, I got white in my beard.
Exactly. Still here.
Yes.
That's great.
Yes, this,
Yeah.
just say, you know what, I left.
And you're
Yeah,
still
I'm
here.
still here.
In
Yeah.
fact, that's, I actually left, I left this courtroom.
Yeah.
And you are still on.
Yeah, yeah, you're gonna come back next time.
Wow.
Yeah, I remember my first day, I remember seeing you. I was
Wow.
sitting at a chair over there.
I was there, but they keep going.
Was I? Okay.
It was you and Attorney Marks.
Yeah, me and
Oh, I
Richard,
wonder
yeah.
how he's doing.
Yeah, you guys were doing a motion. For a guy who shot somebody and I think he died.
Narrow it down very
I was gonna
much.
say, that's like half the cases.
It was probably Lamorris Godfrey.
No, he was, I think he was from Jamaica or something like that. It was a convenience store.
I remember this. I don't remember the guy's name, but I do remember this motion.
Yeah,
Um,
and he had some kind of food truck or something.
yeah,
Yeah, I remember.
yeah, I remember the convenience store shooting.
Yeah.
I remember the camera.
Yeah.
There was a self-defense claim.
That was.
That actually ended up not being us. So I think a private attorney hired on that. Got hired on that. I think they did, 'cause I remember the guy.
Yeah,
I think it was Melnick that got
I
hired.
think he ended up taking a plea. And
Probably.
I took that.
It was it was a self-defense case.
Yeah. And it was a community motion.
Yeah, he's doing appeals.
Yeah, that's what he said. That's what he, in fact, he kept emphasizing, I don't think I should be here. I think this needs to handle.
Yeah.
It's not gonna be.
I don't know when Mike's gonna retire. Yeah. It's a question, certainly. Yes.
You have any idea of any possible pleas?
Not yet.
I asked the same thing. No, everyone's in custody.
It just. And I thought, I want to break it like, oh.
I think I'll do it sometime. Thank you. Well, did I ever get some on my last guy? Probably did, but I can see if I had some. No,
Who?
did Juan? We never really got anywhere, because I said we had a bond of. Can't give him reckless and fleeing. He got a bond of, 5,500. We've been in 128 days, that's all the notes I got.
What do you need from me? I'm not gonna go
You said
off
you
the
was gonna
fleeing.
look.
Okay, I'll look.
So at least look.
I'll look.
My name up here anyway. Why are we like this? We know what it is.
But I'm telling you, when I realized how much you really feel my dominant. I went to turn my steering wheel and was trying to guide it and was like, oh, no, I can't do that. And that's when I finally thought, okay. Because that's dangerous. Mama is. It's one thing if you push a door open and bring it there and bring it back there. Yeah. Oh, man. Do you know what?
Don't lie. Joy,
Hey,
my food.
you look nice. Got a fresh cut
Always.
for the weekend.
My food.
I didn't bring any food today. I'm trying to get out of here. I'm trying to get out of here. It's the
How
weekend.
y'all trying to get out? Y'all got 19 people.
That aren't brought up.
Aren't you in charge?
You said you in charge.
I think you are, right? Isn't
Have y'all talked to the defense counsel? Y'all got pleas? Y'all got.
We don't know if we have pleas because they're in custody.
Say, have y'all talked to the defense?
He is.
Okay.
We're waiting on inmates.
How y'all waiting on inmates? Y'all can talk to each other and then relay whatever y'all need.
We gotta
We've
know
done
if they
all
wanna
of that,
take
thank
it.
you. You're late to the party.
Thank you, thank
Right.
you.
I have to protect my lady, so.
Yeah, I ain't protecting.
I have to protect her. I'm a
Thank you,
defender
buddy.
What did she say? I don't know if we, so therefore,
And
I don't know me that you haven't talked.
Because your people are not.
We're done
We've
with that.
talked.
Okay, well,
We've talked,
901 open 24 hours,
we've
right?
talked.
901 open 24 hours?
Let's talking to them if we got no offers.
Again.
But we
my
haven't
point
found-
exactly.
Oh
You made my
Ah.
point. You made my point.
Where are the inmates?
You made my point.
Where are the inmates? It is 11:05. Court started at 9.
I don't know what the point was.
My point was, I asked, have they made, it's like, we can't talk to our people, they don't have offers. Y'all need to talk me into get an offer,
They got.
I did talk to them the other day and got an offer from somebody else, but.
but not the one you need.
Okay, so.
Where are the people?
I'm just saying.
You count, don't be disrespecting your elder.
I ain't
Who?
disrespecting. I'm just
Well, the
saying.
elder guard.
I'm calling it what it is, spade to spade. Spade to spade.
Well, the elder guard.
Your auntie don't care, hate good
morning, Auntie. All right, all right, all right.
How you doing?
Read it,
I
could
have sworn that they brought these guys up, because I had an.
They just, Scott
Scott went
said,
down.
They moving them now.
yeah, bro, he went just to get them, just now.
Hey, what y'all need? Ask Scott what they need, what help do they need? Ask Scott what help do they need? Yes, is Scott down there? All right. I'm trying to understand. So we just finished the closing for the other one? Okay, so that's probably why.
Yeah, they finished it like 10.
Is anybody that y'all don't need brought up out of the 19?
He already got who I didn't need.
I need everybody. They all got it.
I ain't talking about needing to talk to them and, hey, this is what we got going on.
You gotta sign the date.
No, I need them
You
to
have
sign
to sign the
it.
date.
They gotta sign it.
Oh, yeah, even if they say no, then sign the date.
Even if they don't want the offer, they gotta sign it.
That guy lived in Abu Dhabi.
Yeah, that's crazy.
I was like, wait, what?
Oh, you got your seat back.
Yeah. Abu Dhabi is
Did you feel like a fish out of water?
Oh my God. You go on vacation soon.
We could. Yep.
I said, I can't wait for you. Please drink a lot.
Great.
No, we don't drink. We'll have fun. It's so crazy. I almost want to work for you going on a cruise, right?
Celebrity and Virgin.
Oh, man.
I mean, that's
What?
Yeah, she's going on
To
vacation.
Greece?
Greece, but it came so fast.
It came really fast.
Santorini.
That's like my dream vacation
You
spot.
gotta go.
Yeah, that's my dream vacation spot.
What are you waiting for? You're gonna do it.
No, for real.
Like when we're, you know, have you been out for before? When you out to sea and there's nothing to do, that's how you're gonna do it. That's all it's been busy. And now people probably go work. You know, oh my God. It's great.
Okay, so a lot.
Cause I've been to the UK, that's the furthest. So I think this one.
So excited.
Yeah.
You're leaving when? What's your kids gonna do with that?
They will be okay.
They will be okay. I don't know if they want to go.
They said no. Who turns out on vacation?
Young people don't value things like that until they get old. Those opportunities sometimes, just sometimes. And then another time they don't wanna go with their mom.
That is true.
You know who got me into wanting to cruise? Attorney Marks.
He loves it.
He would always talk about cruising. It's just something. His cruises.
Yeah, I've been on a few, but lately, every time I come off the boat, I have COVID.
Oh.
I think that's what happened to me last time.
You remember you were sick.
Yeah.
So you be careful, that's the only thing, because of the closed
Spaces,
quarters.
yeah.
And for me, COVID is always, most, it's had it 4 or 5 times, but 2 of them were bad and 2 of them were okay. Wow.
Yeah, so how I realized, first I thought I had a cold. I think I got it in the summer. And I was getting ready for work. I sprayed perfume and I couldn't smell it.
Oh,
And
oh, wow.
So I knew I could come in.
Just load up on your vitamins to boost your immune system.
Yeah.
Just load up.
And I'm thinking,
Yeah. That keep
I'm not looking forward to a long flight.
How long was the flight?
16 hours.
Yeah, that's another. Now, I have created a, this all, show him on this. I have created a life.
I'm good.
I used to call it a bucket list, but I was like, no, it's a life list. And one of the things on my life list is to fly a Philippines trip on the Delta one. So that I can be very, very comfortable with, and my grandbaby wants to go to Greece for her 26th birthday.
Oh, that'd be so nice.
I will see, but we want to fly on Delta One, so she says, Grandma, will you pay for my? I said, girl, I'm trying to pay for my, cause the flight was like 1,400, we just kind of looked at the Delta One flight, $7,000. I was like, I don't think I'm flying you off Delta One, baby. It's my only grandbaby, so.
Oh.
Something happens and I get a whiff of mine and she going on Delta.
Oh.
Huh? 8? Well, see, maybe it's the time y'all going, but when I looked it up for next year, it was like 1,700 for a round trip flight to Greece. So I don't know. Where's home? Oh, it's nice though.
You should go home. You should go during the holidays.
Yeah,
It's
you should
nice,
go.
and it's not for a funeral, it's for a happy occasion.
That's the last time I went. For a funeral.
Right.
Yeah.
I told her she needs to go when it's for fun and
Yeah.
nice. Yeah.
But 25 on here.
That is a lot.
And.
Why is it so high? Well, it is Christmas time.
I saw her that was, you know, we're going, I said, all you did was light spirit.
How long is that flight?
And you earn less.
How much is it on Spirit?
Was $200.
Or you better go on.
You better be uncomfortable for 2 hours.
Yes.
Now for 16 hours, I'm not gonna be uncomfortable. But for 2, I'm
You better
ready.
close
And
your
it's
eyes.
nonstop.
You better close your eyes and get on that plane.
Buy a neck pillow.
That's like 10% of what, see, I didn't have time.
Yeah, you might have to be uncomfortable. Yeah.
Go to sleep.
I
Right.
like my Delta too, I like Delta.
Me too.
Mighty spirit has done.
For here. I was like, I was like, I could have, that's why I started, I could have, whatever that is. I'm sure he's gonna keep running, right, because like. Did he? Or not? Yes, he did. That's like the fourth version. He said, y'all ain't got it. First he was like, y'all ain't. He said, not because of how he's talking. Yes, she was like, yeah, we're talking about how it's always she's like this, right? And I need to show you that possible. To carry this. No. Here. So the old that is a press conference. So the only way it gets here is him who is here in his right. It's holding the gun, and then the gun. That's the whole gun. Face. This would do. Yeah. This is no problem. And I said, my son, I can see. Talk to the mom. Clearly she's. She's not coming. But that's what I saw. That's what 5 years of service. I would understand kind of say on that 2025.
Is your case with Jocelyn going to be a plea? I forgot.
Thomas?
I hadn't talked to her.
Okay. Your purse, yes.
I was like, where's my purse? Okay. I let you a story.
What story?
About the dog.
About the dog and the peanut butter? Oh. The clicker. Abby, I mean, Kay.
Yes.
You found it?
I just found it.
Awesome.
It was in my junk drawer thing.
You tucked it away from yourself and you didn't even know.
And I didn't even know. I love your accent. It's so pretty. Okay.
And you probably gave up looking on it as far as.
What?
That's yeah.
Yeah, and I.
Because he claims it up when you stop looking.
Yep.
Did he wake up that one? Absolutely. Right. Speak of. Where, you know, hypothetically, what if, hypothetically, nothing, so you don't get it, easy, go to profits.
My gang detective brought me cake. My lead detective brought me soda.
I don't.
I was feeling loved.
That's mine.
Huh? Oh, yes, ma'am. Oh, yes. Yes, ma'am. It's just a natural progression of things. Then you go to major case and then. No. No, only when I go out in the street, like when I go out to do investigations, but no, when I go home. Mm-mm. Miss Ortiz, I got what you asking for. He's in, that looks delicious. Look at that. Only thing is missing is the nut.
You can't eat nothing else for the day.
I'm not gonna eat this whole thing. Brown, you want some cake?
Good job.
County cake is that green?
Huh?
County cake is that-
You take a good,
Or county cake is that green?
what cake is red?
Probably doesn't fit into his macro.
Right, Mike. I can see that. I can see that.
Doesn't fit.
It doesn't fit.
You could just get a little.
You would have to starve for the rest of the day.
That's when people mess up that.
Oh, you go, he's
Within his. macros.
within his brain.
Got it.
Oh, yeah, this is going down. Man, so what a nuts at?
I thought you had the one without none.
No, I love the one with nuts.
I had to take a while, I guess, I'm like, I don't know, I think she had one without none.
You could have just gave me one with nuts, and if it was an allergy, give me a Benadryl.
Yeah, that's what I thought.
That's-
Give me a bit of
That's what she does. She's allergic. She eat the one with nuts and then takes a
And it takes a
Benadryl.
bit.
What's wrong? What's wrong with her? If you look, her purse is full of medication.
That is crazy. Willing to take the risk, that's wild.
And the crazy part is that's all she eats, is the nuts and icing, not the cake. The light is on.
Really?
The light is
Where's
on.
that Scott?
I don't.
Where am I?
Where's everybody?
Light is on. I don't think so. I think they just see they're certified. Can't be. The light. Oh, I wanted the can. That was the whole thing.
Well, I figured this one keep close.
Thank
I made a
you.
game time decision.
I always thought you, these ain't either have a question or something.
It's all about earnestly seeking.
But it's been a.
We're trying to figure out.
It's been.
Oh, so it's not the live, right? You know what you're talking about?
I'm talking about the jury light.
Okay, I thought you were talking about the live, so they can still see us live.
Mhm.
Yeah, the
In
in
here,
here,
in
in
here.
here.
it down.
So
be
what do
mindful.
you do? You eat the nuts, you eat the nuts and then take the Benadryl?
You know where it's gonna go. He says I already drank it. I got it, the epic pen.
That's crazy. I've never heard someone to intentionally. The light is on, Scott.
How long you been on?
For a
It
minute.
just-
Okay,
Just came on.
okay,
Cause it wasn't on when I was just out there.
okay.
Thinking they do it 1300.
Well, I'm gonna kick you out the courtroom. Something like a home to it.
I mean,
That I told y'all yesterday that
I'm
she
look.
finna come out, so we get a prayer, I did like this.
Look, I look over.
she did like that and took her wig off, right?
I had to look. When I'm saying this door, you all in. So y'all thought I was looking like that because the cake company she made. I'm looking at.
Who that homeless man?
I'm looking at Mason like. Then she walked up to him. I had to look like.
That's
Okay.
not messed up. That's just real.
Then I had to look like.
Y'all are
Don't let him keep going like that.
You know, but you know what? Everybody have bad hair days. That is true. That is true. I need some rest. I need to take these off.
It's gonna stay off, clearly.
I did like this. Came up.
I ain't good for your hair person.
Huh?
I ain't good for your hair person.
I like all of my naturals. Like,
I gotta watch.
where your grades at?
I got grades, don't do that. Oh, my grades, so.
But it look like the rest is
Never
tiny.
that.
You trying to say he a young,
Trust that.
he a YN.
I ain't know why I ain't. I got grades, I just don't, I don't hide my grades. My grades don't go up there. They go up there with you.
Oh,
I don't have no grades in that.
Hey, not
Yeah,
you trying to
with
be a
the right
YN.
spray, of course you don't.
I can literally watch my, I can go outside and when it rains,
For real.
and don't worry about
It
it.
ain't gonna bleed down.
Y'all heard, you know,
I don't have
you
no
put that
Beijing.
Beijing on,
I don't have no
your
Beijing.
shower pan be black. That was the same.
No
I
way.
don't know.
See, y'all done got it bad since it
Look,
started. This
I can
ain't
do
good.
this. I can do this. I can lick my hand. A lot of people can't do that.
I know.
Yo, we don't lie.
I can sweat.
I know, right,
A lot of
baby?
people, a lot of people can't sweat.
Baby thinking they marker sweat. She like, what it called? Beijing.
I know my barber shop did that one time. I think from my 40. He's like, oh, you high definition.
With the white one?
And he just did, he don't do a lot of people spray. So I'm sitting in the chair. He do like the face one and all that. So he's like face one. He's like, I'm about to sauce you up in spray. So I'm like, okay. I said, look. I'm spraying.
Man, I be asking them why you lying. I be like,
Oh,
y'all
look at
showing
this.
y'all body out like y'all got them dead.
So only it highlights the edge.
Show your hairline.
That's what I'm saying. Like you doing them dead body. You know, chop.
It highlights the
Where
edge.
y'all get that
No,
from?
don't encourage her.
Where y'all? I wonder where they get the white chalk. Was it inspired by homicide scene?
It's inspired by
Yeah, where
women.
did that come from?
It's inspired by women.
Women encourage
Yeah,
white
yeah.
chalk around
The
the
white
hairline.
line. What women have put chalk on their
So no, real talk. You know how the women do the makeup to bleed in the lace?
To
front?
blend
To
in.
blend it. So the chalk line blends in the.
It never does.
That's what it's
Have
supposed to
you?
do.
That's how we know it's a
They
chalk
be
line.
looking like a whole homicide
But that's
scene.
what it's supposed to do though.
I be
It's
like,
supposed to be. So it's like a makeup and you use. And then it
nah,
just
I
whitens.
seen them folks put a pencil chalk.
Yeah, it just
Oh, yeah.
whitens.
Chalk them folks head.
My barber don't do that. My barber doesn't do that.
Well, I be trying
I
to
think the
figure them
purpose
out.
is so that you can clearly see.
Clearly,
But
you can
I am not
just use your
receiving.
eyes. I mean,
I got start to finish. I got my. Start to finish. Oh,
look at you all proud.
so when everybody see.
You almost 50 and you
Just
still got
what I
your
said.
mind. You had done.
So when everybody be like, oh, there you go. Yeah. I just see that. But you, as you can see, I don't do no.
Yes, ma'am.
You don't like want enhanced meat. That's what you need.
Yes, ma'am.
That came on you like you did. You got the plastic.
No, he's not. I don't even know his number.
But you gonna start to finish.
It's plastic. Old school cake.
Start to finish.
I don't know what to do. You want me to email
I'm
him?
gonna make a new cake for y'all. It's gonna be a shower curtain, but I'm gonna make
Sorry?
it a shower curtain.
I'm just saying though.
But I'll shower
Okay,
curtain.
all right.
I'm gonna start finish my.
I can go start and
So
finish
then-
when I wash my hair.
Okay.
I
need to look up.
That's not in the, it's not in the memo.
It is. That's why people ask me, I'm like, how much
How much you charge? That right there.
Them barbers done got, what happened to the 25, 35, $40 haircut?
My son pays 65. And only thing he get for shape up, I mean, a taper in there.
Now, a haircut is $100.
I pay 106.
That is crazy.
106.
I can buy a whole wig for 106.
106, yeah, too.
And the blue for 38. We got game value. I need that.
But now,
But they did say the hair industry is $1 billion industry.
but now these females who be doing these hair units for me, they the ones who.
Yeah, they the ones. I agree. They are making the most money.
You gotta come in, she takes her wig off, he take his wig off.
Oh, my God. I mean, I can't fix nobody because I took my shit off. I be like, look, I'm irritated. I gotta take you out. But I live alone. I'm gonna be the passenger seat at Chili's till I watch it.
So how you feel the jury coming out?
They know that I'm like, they know I am what I am and they know I am what I presented. So when I be flipped on the ground, I'm in plain clothes. So get what they visualize and see me in the plain clothes.
Okay.
You get what I'm saying?
Okay.
In the
The
flesh.
professionalism was yesterday.
Yeah, yesterday, but I'm in the flesh. When I'm gonna feel contact, when I'm going up to
You
them,
look like it
you look like it
with cap and all.
with the count gown.
Mhm.
Oh, yeah. All day, every day.
You could just say, we don't want to dress up today.
Yeah, you
that
could have
was-
just
that was
said,
just-
I don't dress up no day, and you know this. This is my regular wardrobe
This is
every day.
straightforward sentence, yeah.
I go to the office every day looking like this.
I'll drive out, I come down, I'll be a slick every day. I'll be a slick.
I don't see it.
Oh,
I just don't see
but
it.
actually in my front room, they gotta tell me, I'm the one that they gotta tell, hey, it's a dress up here. I throw some shorts and sweats.
This is me every day. I sit in office, me go out. This how I
What
get
the other
my
question?
Okay.
He trying to be cute.
It's because they have bicycle on, so it stretches. You got that thing on?
I put Latin down. I'm just
They
saying.
They trying it.
Yesterday, I got my left cane roll. Y'all don't wear
So you
left.
got heels?
Hey,
I have on boots today, boots on the ground.
I don't wear left cane. When I got when I used to have to work, when I used to have to public,
It was a little nippy.
Yeah, it was.
It's like 55 degrees.
I didn't expect that. We used to do that too, in a hotel room. They used to.
Somebody, let me hold it. I didn't go. Sorry.
You good?
Comments say that you don't know what working, so. You mean, do some work.
No way.
Yeah.
I've seen you try to do it, stuff like that, yeah.
And then sometimes I do, we saving their life too. It's just resetting off. Yeah, so it's just those two. Yeah, that's okay.
Yeah. 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 You, said discovery. And you said
Yes, I said
over.
discovery.
That's all things that I asked.
No, but yeah, discovery is seven more, just already treated.
Yeah, just. Hey, so you hang tight, we're gonna bring one down and bring one up. I got you.
Wow, red on it?
None of the defendants were up, so they haven't talked to him.
So it's just Dennis.
Yeah, that was your last.
Right, supposedly.
You gotta take from.
Oh, just beat it, don't, let's see.
They do.
I don't know if that's what. Shell kill.
Between up here and down there, I'll just make sure. And then I had to come over here to make sure.
Just stop that.
What? Oh, the
Question.
missed call?
No, we have a question.
Yeah, we have a question.
Keep texting.
Yeah. Right.
Like how I had it here.
We don't.
You're gonna have a question, what you
have to say. Go to the points where we have to say it.
No, I doubt that's the question.
Wasn't funny then either.
And you could say yes to that just once on a particular charge, not all. Yeah.
Oh, yeah.
You just gotta kind of be able to articulate it. This ain't the gym. You gotta be able to like, it's like a manipulation.
Yeah, thank you. Just came back out here. Just
I'll be in here. Yeah, I'll be in here. Watch dress.
Oh, I know what the question is.
What is it?
I don't know if you could have half and half veggie and half meat.
Find something to do it. Oh.
We think it's a question about lunch. Oh, they're having lunch now? Oh, also,
I thought there was a question. I thought there was a question.
I thought it too.
Oh, the question was about lunch. Okay.
so they don't have a question?
Hmm?
So they don't have a question?
I have no idea. I would like to eat.
Oh, they do? Okay. Okay.
Let me just have a little.
Hmm.
Yeah.
I got you. I was gonna, I didn't see you.
All right, we'll bring out Mr. McCoy and go on the record in just a minute, but it's a pretty straightforward note. May we have Manson's PowerPoint? So. mm, will they have another note? I need to bring out McCoy and do some record stuff. Okay.
Yeah.
Oh, really?
But now I'm at all like sitting out talking when I get the message.
All right, you ready? We are back on the record. Jury's been deliberating approximately an hour and a half, and I received a note from them about 20 minutes ago or so, which I have marked as Court's Exhibit 3 and will tender for the record and is available for the party's inspection. It reads, may we have Manson's PowerPoint? And it is signed and dated by one of our jurors, and I believe the appropriate answer to that would simply be no, without, unless both parties consent otherwise. Any input from the state?
A simple no. It's okay.
I agree, Judge.
Or you have everything.
Right. All right. So I will just write no. I've written that, signed it. You can show that to the parties. Unless there's anything else, we will go back off.
Show it to the parties.
I'll go back off the record and we'll remain in recess until we hear further word from the jury. It does appear that they are working through lunch. We're off the record. Let me check in with our regulars. Anything we want to get into with y'all? Y'all just still plugging away? All right.
I got a couple of pleas.
Yeah, I've got one or two.
Yes, I'm just telling Miss Smith, she likes it.
She doesn't. She
And I
should.
always forget.
Let her know. All right. Well, just let me know if you want to take them piecemeal or all at once or whatever you want to do.
Green. Collins?
Two columns.
So F. That's a plea.
Yes.
Did Moran enter an appearance for the second case?
He's under both.
He's gonna do both.
under a waiver for both.
Great.
And.
Did you say you wanted this?
Yes. He's number.
You sure this is correct?
Okay.
I'll step out.
That was a voicemail.
Okay.
Okay, so did you find your paperwork?
See the name?
Oh, I didn't see it.
Another one? Oh. This is for sure.
Where's the? I'm sorry.
Sure.
I have two. One is not a very, yeah. And Mr. Okay. Yeah, another one. Where? I do. They just got it. I told the son. Yeah, I'm just asking, just so, you know, I wouldn't, I thought it was in, that's why I didn't really try.
I don't know what happened.
Okay.
By the car, I guess.
Got in that hole?
No, I think that's the first one I looked in. Sure.
Oh, you get one of them that talks to you. Okay, let me figure it out. Okay, we just happened. I didn't ask. Oh, thank you. Yeah, tell me to stop calling. It's called about 30 times. You did.
I've got a lot of files. I think
Okay.
they're with me today. They're in the car. I just didn't want to bring the whole bunch of them here. I'll have to run back when I get a chance.
Okay.
Officer Julius.
Ms. Fortis, are you sure nobody tried to pick them up that day?
Judge will be the one to ask for him. That's the only one left.
This has happened before, not here, but in a lot of places. It's just,
Yeah, because it was so late.
yeah. I mean, I've had it come up a lot of times, places where they just take them up. They generally leave them on the table for the jury clerk.
Yeah, he was the clerk. That day.
Oh, the judge was.
When I saw the name, I was like, wait, what?
Yeah,
Seen
I
it.
You don't hear it?
I actually don't.
Or the advocate from each other.
Get advocate.
That's why I look comfortable. Pass off the wrong information.
Oh, okay. I thought they were gonna come out for that question.
They typically don't.
Oh, okay.
Funny, I said they're gonna want a video or something like that. I remember the first day. You always really serious that. And one of them, there is.
I swear you could.
I feel like the person. That's funny. Some people only what? Yeah. I don't know.
Hey, how you doing?
What happened?
What happened, what?
To your case.
My case with you?
Yeah.
You talking about Ron McDonald's?
Yeah.
Chineke will offer 10 cent one. Hey, how's your wrist? What happened?
I don't know. But
Okay.
it is to the continent where I didn't know if I'm
Yeah.
Miss Hornsby.
Wow.
So, yeah.
Okay, so I really haven't missed anything. is what you're saying. Good.
But I just wanted,
I'm glad you corrected. I'm glad you
Who's first, Mr. Davis?
If they don't mind, I would, but they got out here first, so I would ask what.
I'm Mr. Davis, yeah. Talk to all the vacancies.
Mr. Marcus Thomas.
Yeah, I think Ms. Willingham has a word with you.
She has a word.
What's a word with you about who goes first, I think?
Oh, I'm sorry.
No, I said that, I would love to go first, but I know they got out first,
Oh, that's
so.
fine.
Do you have one together?
He has one, right?
I just have Mr. Davis and then the other one, if it please, it's with Mr. Siminoff. Joy's gonna take it. I need to go to urgent care,
Yeah, so you can
so.
go first. I mean, I'm all right with that. 'cause I
Okay.
have to.
Let's do it.
You gonna bring Mr. Davis out?
Doesn't sit over here now.
All right, so Mr. Davis, anyone have a position on that?
It is position 16 on clean arraignment.
Notarians.
The tyrants.
The tyrants, got it. Mr. Melnick, well,
How you doing, Judge?
Mr. Tyrants.
Okay. Okay.
And I'm just, it's a misdemeanor. Yeah,
Yes.
and he is using first offender, just so everybody knows. Huh?
Qualify for, I don't know.
I've seen it spelled that way before. I've seen it spelled NYK before as well.
We are on the record now, position 16 on our plea and arraignment calendar, 25 SC 005440 State versus Tyrants Davis, who is present in court. Along with this counsel of record, Mr. Melnick, State is here through Ms. Willingham. I understand Mr. Davis wishes to enter a plea of guilty. Ms. Willingham.
Yes. Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can put your hand down. Please state your true, correct, and legal name.
The Tyrants, Kieta Davis.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
How old are you and how far have you gone in school?
I have went to general equivalency diploma. I'm 25 years old.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am, I do.
Have you had enough time to speak with your lawyer about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am, I have.
Do you need any more time to discuss the case with your attorney?
No, ma'am, I do not.
Are you satisfied with his services?
Yes, ma'am, I am.
Counsel, are you satisfied your client has a full understanding of this proceeding?
Yes,
Have you reviewed the indictment in this case?
yes,
Do you waive formal reading of the indictment?
we do.
Has your client been arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Do you or your client know of any outstanding warrants related to these charges?
No, we're not aware of it.
Mr. Davis, do you understand that you are entering a guilty plea to the following offenses?
Yes, ma'am, I do.
Hold on, Mr. Davis, I have to read them. I'm sorry.
Yeah.
You're entering a plea of guilty to battery, family violence, misdemeanor. The state would make a recommendation of 12 months probation. And count one of this indictment is going to be non-pros, Your Honor. And you would be entering a plea of guilty to count 3, cruelty to children in the 3rd degree, with a sentence recommendation of 12 months probation consecutive to count 2.
You would be required to complete the family violence intervention program, have no violent contact with the victim, and complete 40 hours of community service. I'm sorry, 30, and no weapons.
Yes, ma'am.
And is that what was explained to you by your attorney?
Yes, ma'am.
Are you aware that the court does not have to accept that recommendation, and the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other?
Yes, ma'am, I am.
Do you understand that if you do not accept the court sentence, you may withdraw your guilty plea today?
Yes, ma'am.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to the revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am, I do.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes, ma'am.
Do you further understand, because this is a family violence conviction, if you are found in possession of a firearm, you could be charged federally?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
How do you plead to the charges of battery, family violence, and cruelty to children in the third degree in indictment 25 SC 005440?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am, it is.
Do you understand that you have 30 days in which to appeal your conviction based on your plea today?
Yes, ma'am, I do.
Do you understand that you have only 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
And Your Honor, I know that the defendant is requesting first offender. There is one thing I'm gonna need Ms. Okuzu to check on. So I'm gonna do the factual basis first, but there is a forgery charge, it looks like. Can you just confirm, Ms. Okuzu, that that was a misdemeanor?
We can use first.
You-
Anything in our system.
Okay.
Probation, so.
That's what I just wanted to confirm. Huh? Hold on one second. Let me go back to it. It is out of Walton County. And because it was in the Superior Court, I believe it is a misdemeanor, Judge, but I just wanted to confirm. So I'll do the factual basis and then I can go ahead and double check that. So if this case were to proceed to trial, the state would expect to show that on August 5th, 2025, officers responded to 1159 Graymont Drive regarding a domestic dispute in Atlanta, Georgia, Fulton County. They met with Ms. Jackson, who informed them that she and the defendant had been involved in an altercation 2 days prior. Jackson stated the defendant would not allow her to leave the residence. Ultimately, she contacted her sister, Brianna Jackson, to contact the police on her behalf. Specifically, Jackson alleged that on August 3rd, 2025, she and the defendant were in a physical altercation. In that altercation, the defendant strangled her to the point she was unable to breathe. The defendant also bit Jackson on the left side of her chest. At the time of the incident, Jackson was holding the hand of her child, Indy. Officers' body-worn camera captured ranges of the bruising. Your Honor, I've had an opportunity to speak with Ms. Jackson this morning. She stated that she wants absolutely no involvement with this case. And when I asked her about the strangulation, she stated that he put his hands around her neck, but that was it. So based on that, I don't know that the state would be able to adequately prove the lack of restriction to her breathing, but based on the injury seen by officers, I do believe we would be able to prove the battery. And obviously, because the child was present, the state believes we would also be able to prove the cruelty to children in the 3rd degree. And for those reasons, the state has made this offer.
Anything else, Mr. Melnick?
Your Honor, Mr. Davis is 25 years of age. As far as I know, he doesn't have any felony criminal history or any felony convictions. We are asking that he be allowed to enter the plea under the first offender statute. Just so you know, Walton County doesn't have a state court, so all their misdemeanors are handled in Superior Court.
That's what I thought. So that was why I was just confirming. I do believe it is a misdemeanor based on the sentence as well, Judge. Hold on one second.
I believe it was a misdemeanor. So in any event, Your Honor, I've spoken with Ms. Jackson as well, and she, as Ms. Willingham indicated, she doesn't want to have anything to do with this case. She doesn't live in the state right now either. This is the result that I think she would ask for.
All right, Mr. Davis, I need to confirm you understand the nature of these charges.
Yes, sir, I do.
And you still wish to waive all the rights that the state explained to you and go forward with this change of plea?
Yes, sir, I do.
And that's because you committed these offenses?
Yes, sir.
Do you have a weapons carry license of any kind?
No, sir, I don't.
And Mr. Melnick, are you satisfied your client is confident that the plea is voluntary and intelligent and that there is a sufficient factual basis?
Yes, Your Honor.
All right, well, I agree, and I will accept the plea. I'll withhold adjudication and sentence you as a first offender, as I believe you have sworn you're eligible. If that turns out not to be the case, the state can file a motion, and there's a remedy for that. And I'll sentence you as recommended by the parties on count 1. Count 1 is dismissed. Count 2, the misdemeanor battery family violence. The sentence would be 12 months. That'd be to serve 2 months with the balance on probation. As I see, you served 66 days already. Count 3 would be 12 months probation to run consecutive or to follow count 2 for a total term of 24 months. The special conditions here being that you're to complete 30 hours of community service. You're not to have any violent contact with the listed victim in this case. You're to complete the family violence intervention program. You're not to possess any weapons. Are you requesting automatic sealing, Mr. Melling?
Yes, Your Honor, please.
Any objection by the state?
No, Your Honor.
All right, then we'll note that as well, finding your privacy interests outweigh any public concern. And so, Mr. Davis, someone from misdemeanor probation will be making contact with you, and you need to make sure that you return that call and get everything started and doing everything that you're supposed to do going forward. Understand?
Yes, sir.
All right. Anything else for the record, Mr. Melnick?
No, Your Honor.
All right, then with that, we'd be off the record.
I'd need to go over this with you real quick. TYRANC. I'll just do K. Is your middle name?
Yes, sir. KEI
Mhm.
AUA
AUA
TA.
TA.
Yes, sir.
What's your date of birth?
December 29th, 1999.
What's your number?
770
Mhm.
824 0236.
What's your address gonna be?
Is it
What happened?
2985?
Just had a brace handy?
2985.
Cedar Creek Parkway. My parents' address.
Is that in Decatur?
Yes, sir.
And what's the zip code? Do you know?
30033. No, 2987.
87. Just really just need the county, to be perfectly honest with you. What's your email address?
DN.
Best of luck. Have a great weekend.
RANCE @gmail.com.
You want me to use your dad as an emergency contact?
Yes, sir.
Oh, wait, before I go, let me email you. So I don't want to forget.
I've got his number. Do you remember it?
Yeah, I remember it.
What is it?
404 707
Mhm.
Oh, yeah, you did
0876.
say that. That's right.
All right.
Thank you.
What is today?
Today is the 10th.
Yeah.
Yeah.
All right. I've got the case number. They can take you back. So like I said, it may be Monday before you get out. Okay.
Yeah. Thank you.
That's 25 005
Yes. And I did confirm it was a fourth degree forgery. Yeah. Good. How are you? Mhm.
She's got her share.
Beslin, is Dennis clear?
That's what I can talk to you about.
Okay. Well, I sent you what
Okay.
what is hers, but hold on.
Yeah.
Carlos Anderson.
What number is that?
He is number 9.
Yes.
We are on the record now with 25 SC 004673, State versus Carlos Anderson, who is present in court this afternoon with his counsel, Ms. Hornsby. State is here through Ms. Rutland, scheduled for plea and arraignment today. I understand Mr. Anderson is entering a negotiated plea of guilty. Ms. Rutland.
Mr. Anderson, will you please raise your right hand? Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You may lower your hand. Will you please state your true, correct, and legal name?
Carlos Ramon Anderson.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
1 year of college and I'm 50 years old.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you've been charged with the following offenses? Count 1, interference with government property, which has a 1 to 5 year maximum sentence. Count 2, possession of tools for the commission of a crime, which has the 1 to 5 year maximum sentence. And loitering and prowling, which has a 1 day to 12-month maximum sentence. Do you understand?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you can have a jury trial.
Yes, ma'am.
Have you had enough time to speak with your lawyer about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, I have.
Do you need any additional time to discuss the case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes, I am.
Counsel, are you satisfied your client has a full understanding of this proceeding?
Yes,
And do you waive formal reading of the indictment?
we do.
Do you waive any and all defects in the indictment for purposes of this plea?
We do.
Mr. Anderson, have you been arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Has your attorney advised you of the minimum and maximum sentence for each charge that you're pleading to?
Yes, she has.
And do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of On count one, 5 years to serve 234 days with the balance probated. Count two, 5 years to serve 234 days with the balance probated to run consecutive to count one. And count two, serve 234 days. You will also be subject to special
He didn't respond.
Yes, ma'am.
Okay. You will also be subject to special conditions, including, you are to have no weapons or replicas of weapons. You're to have no drugs or alcohol without a valid prescription. You're to stay away from the incident location.
Yes, ma'am.
Are you aware that the court does not have to accept that recommendation and the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after another?
Yes, ma'am.
Do you understand that if you do not accept the court sentence, you may withdraw your plea?
Yes, ma'am.
Do you understand that you may not withdraw your guilty plea if the court orders a sentence other than your counsel's recommendation?
Yes, ma'am.
Do you understand that you have until the end of the term of court to file a motion to withdraw your guilty plea?
Yes, ma'am.
And do you understand that if you chose to file a motion to withdraw your guilty plea, the discretion to grant that motion lies within the discretion of the court?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand the general conditions of probation?
Yes, ma'am, I do.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that if you are charged with a crime in the future, this plea may be used to enhance sentencing, including on a federal case?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes, ma'am, I do.
Are you a U.S. citizen?
Yes, I am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following trial?
Yes,
For
ma'am.
example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes, ma'am, I do.
Do you understand that you waive any and all defenses, including any mental health defenses by entering a plea of guilty?
Yes, ma'am.
And do you understand that by pleading guilty, you are giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses against you and to question them, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove you are guilty of each charge beyond a reasonable doubt.
Yes,
The right
ma'am.
to testify on your own behalf or remain silent, and the jury would be told they cannot use your choice against you. The
Yes,
right to
ma'am.
present other evidence of your own and call your own witnesses if you chose to, and the right to appeal if convicted of these charges after a trial. Do you understand?
Yes, ma'am.
Counsel, are you satisfied your client understands these rights they'll be waiving by pleading to these charges?
Yes, I do.
Mr. Anderson, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
And is it your decision to waive the rights we just talked about and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
As to indictment 25 SC 004673, how do you plead?
Yes, guilty, ma'am.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you have 30 days in which to appeal your conviction based on your plea today?
I do.
And do you understand that you have until the end of this term of court or 30 days, whichever is later, to move to withdraw your plea?
I do.
Do you understand that you have 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Your Honor, had this case proceeded to trial, the state would have proved beyond a reasonable doubt that on February 18th, 2025, officers responded to 1110 Hammond Drive in Fulton County, which is regarding a suspicious vehicle in the parking lot of Arabella Perimeter Apartments. Upon arriving on the scene, officers spoke to the reporting party who stated they observed a male come from behind of the back of a Jeep Wrangler and enter a Mercedes SUV. They went into the lower area of the parking garage, which is only designated for residents. They located the vehicle idling in a assigned parking spot A188. Officers parked their marked patrol car behind the vehicle, and upon approaching and identifying as law enforcement, the driver, later identified as Carlos Anderson, sat up from his position inside the vehicle, placed the vehicle into reverse, and pressed his foot on the accelerator. Officers gave commands for him to turn off the vehicle and exit. The rear of the suspect vehicle struck the driver's side of the fully marked patrol vehicle. Anderson was removed from the vehicle and detained, and a search upon the vehicle yielded a DeWalt power grinder, a saw, 4 pry bars, a rubber mallet, bolt cutters, a samurai sword, and husky toolkit. All occupants were arrested and transported to jail, and this all happened in Fulton County.
And as I understand it, Mr. Kuzu, there's an outstanding probation issue.
Yes, Your Honor, for 11 SC 104826. The violations in the petition are the charges he's been pleaded to.
All right, and how much time does he have remaining?
He has 5 years, 9 months, and 27 days left on probation.
What were the nature of the charges?
The charges he's taking today, he's pleading to today.
I mean, in the original case.
Oh, and the original case was theft by receiving stolen property, count, and giving false info to law enforcement officers.
Any outstanding conditions or restitution?
Don't believe so. It wasn't stated in the petition, but I will look through the document.
All right, so is the joint recommendation of the parties 7 months to serve and terminate? And since this would end up being swallowed by the 10 years of probation that he would be getting on this case, Ms. Rutland?
Yes.
Anything to
Yes.
add on that, Ms. Hornsby?
I'm sorry.
Anything to add on that?
No, that was what we were agreeing, because this would run longer than what he's got left. But is it time for me to say my part? Are we still
Right
on
now, it
probation?
is. Turning it to you. Yes, ma'am.
Okay, thank you. On behalf of Mr. Anderson, he is 50 years old. He had not that it's an excuse for anything, I'm just giving the court, he had a mobile mechanic business where he would go around and work on people's cars. And I mean, he had actually, that's where all those tools that in there is from his mobile mechanic. He also does welding work. But
What's the samurai sword for?
no, I don't know about that. But it definitely wouldn't hurt anybody or whatever. It may just be a collector piece. I don't know.
All right.
Okay.
There we go.
But since he's been incarcerated for this 234 days, he has availed himself of the certificates that that the jail allows. He's done 67. He's even individually kind of reached out to several programs through the court so that when he gets out, he can hopefully get into one of those. I think he's close to getting into PAD, which I know we talked to the court about. But we're just asking Your Honor to accept the recommendation. He does have 2 kids, 14 and 16. He's originally from Kentucky, but he's been in Atlanta since he was 16 years old. We just ask you to accept the recommendation.
All right, well, I'll note that the tools enumerated in the indictment did not include a samurai sword. So if there's going to be a motion to return the property, I don't know if that's something he wants back. That's something you can follow up with Ms. Hornsby about and present that. And I don't think APD can be holding that in property much longer after the conclusion of this case. But Mr. Anderson, do you understand the nature of these charges?
Yes, sir. Yes, Your Honor.
And you still wish to waive the rights the state explained to you and proceed with this change of plea?
Yes, Your Honor.
And that's because you committed these offenses?
Yes, sir.
And Ms. Hornsby, you're satisfied your client is competent, that the plea is voluntary and intelligent, that there is a sufficient factual basis?
Yes.
All right, I agree. I'll make those same findings, and I'll sentence you, Mr. Anderson, as recommended on count 1. The sentence would be 5 years to serve 7 months with a balance on probation. Count 2 would be 5 years probation to consecutive to count 1. And then count 3 is 7 months to serve concurrent to count 1 for a total term of 10 months to serve 7 months with a balance on probation. Your special conditions here would be that you're not to possess any weapons or any replicas of any weapons. We'll make that firearms to be specific. And You're not to possess or consume any drugs or alcohol without a valid prescription. You're not to return to that location. And for any technical violations, those will be handled by your probation officer directly under the sentencing option system with a sanctions cap of PDC or RSAT. Do you have any questions, Mr. Anderson, about anything we covered here today?
Yes, sir. Do I have credit for the 234 days I've done?
That's what that 7 months means. You're going to get full credit for the entire time, but we just round down for the purposes of this sentence and say it's 5 years to serve 7 months.
Yes, sir. I understand.
Any other questions?
No, sir.
And,
All right.
and just after he does the first round of probation, 4 years and some months, if he successfully, can he go on non-report?
As I understand it, after the first 2 years, that's as a matter of law.
Okay.
As long as there aren't any violations and he's completed all these other terms, that just happens.
Your Honor, I'm sorry, for the revocation, we would just be revoking McAfee's in.
That's right. For the revocation order, we'll make that 7 months revoked, credit for time served, terminate the balance. All right. If there's nothing else, then that'll resolve this case and we'll be off the record. Good luck, sir.
Thank you.
Thank you, sir.
Good luck, Ms. Anderson.
Thank you, ma'am.
All right. The other ones.
Let's hold just a second before we bring out anybody else. Want to see what the jury's up to? Can we get Mr. Cowan a call? You see if he's in the hallway. Ms. Vortis, if you could give Mr. Cowan a phone call, we have another jury question. Okay, on. Court's 4, right?
Yes.
Last note was 3. Right. 10. Sorry? All right, I think we can bring out whoever we had next. Ms. Hornsby, I think you said you had somebody else.
I'm waiting on Ms. Porter.
Okay.
She's the agent for that.
Judge number 2 on the PMA.
Okay. I don't know how long it's going to take Callan to get here, so I don't know if we can do another plea in the meantime. Let me just Miss Rutland stepped out. All right, no, but it's gonna. I understood.
I can make someone else.
Yeah, I just wanted to get my notes here. So you just want to take it from the top, feel free.
Yeah, number 1, Judge, we agreed to look the bench more at the next submitted for track behavioral health report. So I will split order today. To get back more quickly. I will split control.
That's just a transfer based on the,
Well, they have to approve it before the transfer order is signed, but it'll be on the first tracks and it won't involve complete. They approve it, we'll just sign the transfer order on that docket.
okay. And, you know, I think this was like her like third judicial hold. I mean, how do we, well, I have to double check. It was, there, I think there'd been at least one other. That's like the age of what?
So she was in rehab in Florida.
Okay.
That's what it was. That's why.
All right.
Detox. So she had no way to contact me or receive mail. So it was that kind of situation.
Okay. So we'll, you know, further notice.
We'll address that problem.
All right. We'll further notice it to case management and hopefully get some word before then on the submission. All right. And then keep it going.
Two is Ms. Willingham, just no cross on that.
Okay.
Three is the conflict. Four is assigned up.
Is that yours?
That's fine.
Okay.
6.7, he got out of jail on the second, so we're gonna reset that.
Yeah, Faith Collins.
Oh, I got.
He had a bond on all three of these.
Yeah.
Okay. That's yours, Miss Hornsby?
Yes, it is.
And Miss Rutland, all three of these are yours?
Yes, it'll be 4.
There's a fourth one.
Yes.
Yeah, there's a bond on that one, I'm sure as well. Yeah. Okay. Has that one been indicted yet?
No.
Okay. I'm just doing notes. We're on Odell James.
He was transferred to another agency. It says City of Atlanta, so he'll probably end up back here.
Oh,
The whole for City of Atlanta.
like a misdemeanor?
No, no, it just says transfer. Yeah, whole for City of
Okay. Okay. And then,
Number 8.
mhm.
We found that we very well, there's a signature bond.
Anything to add, Miss Rutland?
No, Judge, thank you.
And there's a 24 PI.
Yeah, he's got a bond on that.
Any idea the charges, what they are there?
They're aggravated assault.
All right. And then position 10. Okay. Is that supposed to be Mitchell as well? And oh, that's what someone did. Okay. Guess we'll see if that Rhodes appeared. Okay. All right, 13. Okay. 14.
Mr. Carruthers, same announcement.
I'm just assuming all these are yours, Miss Rutland, unless you tell me differently. Okay, 15. Is that same thing, yours and Rutland's?
Yes.
Thank you. Position 16, we handled 17, Collins. Shambrea Goodman.
That was Moran.
Oh, that's Moran. Okay.
He's out of the way.
He's doing the waiver on that one. Okay. Further noticed. Is that yours, Miss Rutland? 17.
Yes.
Okay. 18 is Jamarcus Thomas.
The next PI.
I got it. And that's yours, Miss Porter.
Your Honor.
All right, we'll be taking that up in just a minute or two here. 19.
Those will just very likely be waivers by sign.
Yeah, they're both yours though. Okay. 21.
21, Mr. Winters, he signed, oh wait, he's got something in Spalding County or revocation on the first offender. I'm checking that, see what they're gonna do and maybe we can do it together.
Understood. And then Marshall. And who is that Mr. Pennington's?
I think it's adult sex crimes, so.
Who, I don't even know who has that now. Is that?
It wasn't Miss Potter. Or no, it wasn't Miss Potter. It was.
I think that was Pennington.
It was Miss Porter.
Yes.
So I don't know who that's gonna be now.
Okay. Okay. And then do we have a supplemental too? Yeah. With just, oh, that's Collins with Moran, and that's gonna be further noticed. What's that? Okay. All right, I gotta turn it back over to Mr. McCoy just for a minute here. So if we could bring on Mr. McCoy, I gotta handle this jury question. Ready? We're back on the record now. Jury having just handed us another question. I've marked it as Court's Exhibit 4 and we'll tender it for the record. And it reads, what's the difference between 8, 9 and then 10, 11? Signed and dated by who I presume is the foreperson. And if we turn to our indictment and look at that, those are the 2 felony murder counts predicated on the different possession of a firearm by convicted felon counts, and then the related predicate acts. So I interpret that as them not understanding the difference between essentially counts 16 and 17, the 2 different ways you can charge possession of a firearm by a convicted felon. So, in terms of the way to answer that, I could refer them to a specific part of the charge where we kind of break that down. Or I could bring them out and explain that to them in person, essentially directing their attention and recharging them on the elements of count 16 and count 17, and then pointing out that those are the predicates for counts 8 and 9, the felony murders. That might be the cleaner way to do it. Again, our charge lists, and it has different elements. I think they're just very subtle differences. So any preference on the part of the state?
I prefer the second, Your Honor. I think it would be clean and straightforward. Is that just for 8 or 9? Or are you gonna do that for 16, 17?
I mean, I think what I would do is I would recharge them on the difference between counts 16 and 17 by rereading the charge. And then I would just point out that counts 8 and 9, that these are the predicate counts for 8 and 9. And that's the difference between 8 and 9.
Right. Will you give them a page number to reference when you charge them?
That's
again?
fine. I'll point that out. Any preference, Mr. Cowan?
That's fine with me, Judge.
All right, Deputy Scott, I'd ask you to retrieve our jury then.
Rise for the jury.
Thank you, Deputy Scott. Please be seated, everyone. Members of the jury, we have received your note asking for the difference between 8 and 9 and 10 and 11, which I interpret as referring to the counts in the indictment. And to answer that question, I would first give you the initial instruction that whatever I say at this point, you shouldn't place any undue emphasis on this new charge and only consider it in the context of all the other charges. But in answer to your question, the difference between 8 and 9 as a pair and 10 and 11 as a pair depends on the predicate act underlying each of those charges of felony murder. And so counts 8 and 9 as a predicate act charge possession of a firearm by a convicted felon, and counts 10 and 11 charge possession of a firearm by a convicted felon, but a different predicate act. And by that I mean counts 10 and 11, the predicate act is count 17. And for counts 8 and 9, the predicate act referred to is count 16. The difference between those two, I'll charge you, that is what again is on page 7 of your jury instructions, which for possession of a firearm by a convicted felon as alleged in count 16, the state must prove that the defendant, 1, possessed a firearm, 2, after having been convicted of a felony. For possession of a firearm by a convicted felon as alleged in count 17, the state must prove that the defendant, 1, possessed a firearm, 2, after having been convicted of a felony involving the possession of a firearm. And so, as I instructed you to before, you consider that in the context of the charge as a whole. Any objections to this recharge on behalf of the state?
None from the state, Your Honor.
No, Your Honor. All right, with that, I'd ask you to retire to the jury room and renew your deliberations.
All right for the jury.
We will be in recess and off the record until we get further word from the jury. We're off the record.
It's not specific, but I was gonna ask for the attorney to stand. I wanted to ask a question, just generally, not specifically. Is that okay? Is that okay?
Yeah, if it's not about this case.
When we, generally.
Trial judge is.
I know, I was like, maybe.
As long as it's an accurate instruction of the law. I'm not sure. You want to check with Miss Hornsby? I think she had someone on deck here.
I think Jamarcus Thomas,
Okay.
disposition 18.
Good description of the law.
Yes. Okay. I know you ain't telling me. Oh, there's no one else in here? No. Are you concerned about something? No. Okay, okay. I'll get up.
Thomas?
No, yeah, yeah, but I have to see it. It's Porter.
Let me get her. She's right in the hall.
Oh, that one's in Porter? Porter. I'm sorry. Oh, I can go there. Oh, I can sit here. Oh, yeah, I can sit here. Yes. I prefer to sit here. Okay. Right. I just didn't know if he makes you get up. Do you mind, can you just see what date? I think it's July 11th. No, I think that's the day he was indicted. I'm not sure. I just want to look at the indictment just to make sure I give the right.
Yes, ma'am.
What position are we on?
No, he's number 18. So you have to speak in the mic. That's the court.
Ready?
She takes this.
We are on the record with 25 SC 005729, State versus Jamarcus Thomas, who's present in court this afternoon with his counsel, Ms. Hornsby. State is here through Ms. Porter. And I understand Mr. Thomas wishes to enter a plea of guilty. Ms. Porter.
Thank you. Mr. Thomas, can you please raise your right hand? Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can put your hand down. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Step a little closer. Thank you.
And is there a medication that you would normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
Graduated. I'm 41.
And you graduated from?
Washington High School.
Thank you. Are you able to read, write, and understand the English language?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that you've been charged with the following offense? State sex offender registry violation.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to this charge? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charge in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Counsel, do you waive a formal reading of the indictment and any and all defects therein for purposes of this plea?
We do, I'm sorry.
Okay. And Mr. Thomas, do you remember having been arrested on this charge?
Yes, I got arrested on August 23rd.
Okay. And the state is unaware of any outstanding warrants related to this charge. Do you or your attorney know of any outstanding warrants that are related to this charge?
I don't believe there are any other warrants on this charge.
Thank you. And has your attorney advised you of the minimum and maximum sentence for the charge to which you are pleading?
Yes, ma'am.
And for the record, the minimum is 1 year and the max is 5 years. Mr. Thomas, do you understand that today you are entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? As to the state sex offender registry violation, the state's recommendation is 5 years probation, and you are to comply with any and all general and special conditions of probation, as well as register with the state sex offender registry within 48 hours of your custodial release. Do you understand that that will be the state's recommendation to the court?
Yes, ma'am.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on this charge?
Yes, ma'am.
And do you understand that if the court decides to order a sentence that differs from the negotiated plea that you were expecting today, that you have the right to withdraw your plea of guilty?
Ma'am.
Are you currently on any probation or parole?
No, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including in the federal courts?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charge against you proved beyond a reasonable doubt, and the right to appeal if convicted of discharge after a trial.
Yes, ma'am.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge to file habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
How do you plead to the charge of state sex offender registry violation in indictment number 25 SC 005729?
Guilty.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
Is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes, ma'am.
And Your Honor, as it pertains to this defendant's criminal history, he is a convicted felon with 20 cycles of arrests in Georgia. He has a burglary and a criminal attempt of aggravated sodomy from 2007 in DeKalb County. And that's the most recent conviction. He has other convictions that are drug-related and entering auto from the early 2000s. And the basis of this plea, Your Honor, this defendant failed to register within 72 hours of his birthday, which was in July 2025 of this year. And this is his first registry violation.
Any revocations to handle here in Fulton County, Ms. Akuzu? All right, Ms. Hornsby.
Your Honor, yes. Mr. Thomas is during this time period for registration, he was experiencing some homelessness and some non-stability. He has gotten his GED and he has a place to live. He was working at this place called Defenders, which was, it's like a
It's cleaning service.
cleaning service, that's what I thought, yeah. And, but during this time, it was unsteady. I have talked to him about registering as a homeless person that they allow, but they have to have some way. Usually he uses his mom's address when he was kind of unstable, but we've talked about it. He's gonna be out in 48 hours. When he gets out, he's gonna go register. And I told him if he has any hard times, he still needs to contact the sheriff's department, let them know where he is. So we're just respectfully asking you to accept this recommendation, and this guilty plea.
All right, Mr. Thomas, so you understand the nature of this charge?
Yes, sir.
So wish to waive all the rights the state explained to you?
Yes, sir.
And that's because you committed this offense?
Yes, sir.
And Ms. Hornsby, you're satisfied your client is competent, the plea is voluntary and intelligent, and that there is a sufficient factual basis?
Yes.
All right, I agree. I'll make those same findings, and I'll sentence you, Mr. Thomas, on this charge to 5 years to serve 1 month with the balance on probation. You get credit for the 48 days you already served. And most importantly here, to prevent this from happening again going forward, your special conditions here will include that you're to comply with the registry, all registry and probation requirements, and you're to register within 48 hours of your release. All understood?
So, yes, sir.
All right. And so, do you have any questions for me, Mr. Thomas, about anything we've covered here today?
No, sir.
Then that would resolve this case and we'll be off the record.
Thank you, yeah.
Take care.
Good luck, Mr. Thomas.
And Your Honor, that concludes my business. May I be excused?
Take care, Ms. Porter.
Thank you.
Wait, so you put your personal sign in? Yeah.
Mr. Simon, you said you had somebody there?
I do, Judge, but I can have a few more ready if you give me a little time. It just,
I think we got some time to fill.
that's fine. I'm gonna have to go in the back either way.
Yeah.
So. But we can get Mr. Collins out here.
All right, we'll just do it and. Hold on.
Faith Collins.
Can we get Faith Collins out?
Yes, Your Honor. Yeah. Faith Collins. I think you're gonna be called for.
But he's doing the whole thing. Okay, all right. I'm sorry.
Okay, right here? Yeah, right here.
We are on the record with position 4 in our plea and arraignment calendar, 23 SC 191882, State versus Faith Collins, who's present in court with his counsel. Mr. Simonoff, State is here through Ms. Rutland. I understand Mr. Collins is entering a negotiated plea of guilty. Ms. Rutland.
Mr. Collins, will you please raise your right hand? Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You may lower your hand. Will you please state your true, correct, and legal name?
Faye Collins.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
31, graduated high school.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you are charged with aggravated assault, which holds a 1 to 20-year sentence?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you can have a jury trial?
Yes, ma'am.
Have you had enough time to speak with your lawyer, Mr. Simonov, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need any additional time to discuss the case with your attorney?
No, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Counsel, are you satisfied your client has a full understanding of this proceeding?
I am.
Do you waive formal reading of the indictment?
We do so away for.
Do you waive any and all defects in the indictment for purposes of this plea?
We do so away for the purpose of this plea.
Mr. Collins, have you been arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Has your attorney advised you of the minimum and maximum sentence for each charge that you're pleading to?
Yes, ma'am.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of, on count 1 aggravated assault, 10 years to serve 2 months with the balance probated.
Yes, ma'am.
You will also be subject to the special conditions that you are to complete an anger management course. You are to have no weapons or replicas of weapons, and you are to have no further contact with the named victim in this case, and to stay away from the incident location. Do you understand?
Yes, ma'am.
Are you aware that the court does not have to accept that recommendation, and the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after another?
Yes, ma'am.
Do you understand that if you do not accept the court sentence, you may withdraw your plea?
Yes, ma'am.
Do you understand that you may not withdraw your guilty plea if the court orders a sentence other than your counsel's recommendation?
Ma'am.
Do you understand that you have until the end of the term of court to file a motion to withdraw your guilty plea?
Yes, ma'am.
And do you understand that if you chose to file a motion to withdraw your guilty plea, the discretion to grant that motion lies within the discretion of the court?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand the general conditions of probation?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that if you're charged with a crime in the future, this plea may be used to enhance sentencing, including on a federal case?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses against you and to question them, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove that you are guilty of each charge beyond a reasonable doubt, the right to testify on your own behalf or remain silent, and the jury would be told they cannot use your choice against you, the right to present other evidence of your own and call your own witnesses if you chose to, and the right to appeal if convicted of these charges after a trial. Do you understand?
Yes, ma'am.
Counsel, are you satisfied your client understands these rights they'll be waiving by pleading to the charge?
I am.
Mr. Collins, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive the rights we just talked about and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
As to indictment 23 SC 191882, how do you plead?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes, ma'am.
Do you understand that you have 30 days in which to appeal your conviction based on your plea today?
Ma'am.
Do you understand that you have until the end of this term of court or 30 days, whichever is later, to move to withdraw your plea?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you. Your Honor, had this case proceeded to trial, the state would have proved beyond a reasonable doubt that on October 11th, 2020, officers were dispatched to 1418 Lansing Street Southeast in Atlanta, zip code 30315 in Fulton County, resulting from a fight at the incident location. Officer Minor spoke to a male identified as Danny Thompson, who stated that his roommate was being evicted by the landlord from their residence. Thompson stated his roommate returned to the residence and jumped on him. During their fight, his roommate, who is Mr. Faith Collins, picked up a frying pan and struck him repeatedly in the back of the head. Officers responded to the scene. Minor, the officer, observed a small knot on the back of Thompson's head, but there was no blood. And this all happened in Fulton County.
Anything from probation, Mr. Kuzu? Mr. Simonov?
Yes, Judge. We're here at arraignment. I've explained to Mr. Collins that he is giving up the possibility of any defenses. And my review of the case, should he choose to go forward. However, he has, despite that warning, elected to accept the offer of the state as tendered. The only thing that I'm trying to figure out is whether he's entitled to a behavioral incentive date. He does have previous Fulton County case from 2014, but I'm not sure if that was under first offender or not. I can't tell if it's actually on his record or not because I don't have the GCIC.
Is it sealed?
It's not sealed, but he has had probation revocations that may have resulted in the clerk unsealing it previously.
What do you have the case number?
It's 14 SC 126373. I'm not sure if Ms.
I have-
Rowland can pull up the
I
GCIC
have
or
it up
not.
now if you want to.
Yeah. Never mind, Judge. It's on his record. So
All right, then. So, Mr. Collins, you understand the nature of this charge?
Sir.
And you still wish to waive all the rights the state explained to you
Sir.
because you committed this offense?
Yes, sir.
Mr. Simon, are you satisfied your client is competent, that the plea is voluntary and intelligent, and with the caveats you already explained, that there is a sufficient factual basis?
yes, Your Honor.
All right, I agree. I'll make those same findings. And Mr. Collins, I will accept the plea and sentence you as recommended by the parties, which on the sole count in this indictment would be 10 years to serve 2 months with the balance on probation. You'd receive full credit for the time you already served in the Fulton County Jail, satisfying those 2 months. Special conditions: you're not to have any contact with a listed victim. You're not to return to this location. You're not to possess any weapons, any replicas of any weapons. You're to complete an anger management course. And then for any technical violations of probation, those will be handled by your probation supervisor with a sanctions cap of PDC or RSAT. Do you have any questions about anything we've covered here today, Mr. Collins?
Yes, about the probation. Because
So,
2024, I had moved out of New York. Moved out of Atlanta. I currently live in New York, so I have a job and I have a fiance that's pregnant up there. So I was just wondering about the transfer of probation back up there because I don't have ID or nothing up here. Everything is up there. I got extradited down here.
Judge, I explained to him that there may be a transfer period of 45 days, I think.
Right.
To transfer up to New York. From what I understand, you have a family member here that you may be able to reside with, but I've explained how that process works to Mr. Collins. And Mr. Collins, there's somebody here from probation that's going to talk to you about that as well after we're done on the record.
Yes, sir.
right, Mr. Collins, I think that you're not the first person to be in that position. I think that they give you a kind of a ceiling that they will have it done in 45 days. I think sometimes they can do it sooner than that, and oftentimes they do. But make sure that you're cooperating with them fully so you can get that expedited, get it done as soon as possible, and they can transfer it to where you need to be. But it sounds like, thankfully, you do have somewhere to go here in Georgia for at least the time being until they can get that handled. But it shouldn't be any longer than 45 days at a maximum, all right?
Sir.
All right. Anything else? Any other questions?
Yes, sir.
All right. Then with that, this matter will be resolved. We'll be off the record. And good luck, sir.
Thank you, Judge.
All right. Has anyone been in touch with Mr. Cowan? Is he still outside? Is he around? Ms. Vortis, perhaps? Have you called him?
I think they're looking for them. Your staff attorney. did-
Okay. So again, Mr. Simon, because I know you still have some folks to talk to, but if you think it might actually be more efficient for us to do as many pleas as you have, because then we have to take a verdict, and then while there's some dead time in the courtroom, then you can be meeting with those folks.
No, that's fine. I just have to convey the counters that were given to me, to the folks before I can announce the plea.
No, of course, you have none, you have no others like ready to go though?
That's the only solid, that's what I'm saying.
Okay, I thought you
have
had
2 or 3 more.
I thought you had another one.
No,
Okay,
that's.
all right.
Oh, they have a big. Yeah.
I know you got
No. Do you want to stay sitting right here?
Yeah, I think she reached him on the phone. Is he not on the floor? Hold up.
No problem. All your hard work.
Wait for his turn.
No, sure.
Balance is no better than that.
It's not long. Their attorney, he's coming. That better?
You thought vacation was right around the corner.
Rub it in, why don't you?
I didn't say that.
Rub it in.
You know, we're going on for a week and a half too, you know, so.
No, when I keep.
Yeah, probably. We bookended you. He's jogging. We ready? All right, if we could bring in Mr. McCoy.
This is a verdict.
Awesome. All right, we are back on the record. All counsel and parties are present, and I've been advised by Deputy Scott that the jury has reached a verdict. And so before we ask the jury to return and publish that verdict, I have to advise everyone here in attendance today that I know many of you have been here for a significant time, some of you for every single day of trial, and waiting for this verdict. However, we can't have any kind of emotional reaction to this, anything that would be audible or disruptive to the proceedings. And so I would ask each of you to look internally and think for yourself if that is something you're going to be able to handle and control. And if you cannot, go ahead and step outside now and you can watch it on our live stream. Otherwise, I have instructed our deputies that they are to immediately escort anybody out of this courtroom should they cause any kind of outburst or disruption. So with that, if we could retrieve the jury.
All right, so the jury.
Thank you, Deputy Scott. Please be seated, everyone. Members of the jury, I've been informed by Deputy Scott that you have reached a verdict. And so I would ask the foreperson to identify themselves by juror number.
Juror 15.
All right, juror 15. And do you have the verdict form with you? Okay, and have you reached a verdict?
Yes.
And was it unanimous?
Yes.
And was that verdict form filled in, signed, and dated by you?
Yes.
All right, if you could hand that to Deputy Scott. All right, ma'am, I'm now handing you back the jury form, and now we have to publish that into the record. And so you can remain seated, but if you would read that verdict aloud.
In the Superior Court of Fulton County, State of Georgia, the State of Georgia versus Anthony Jared McCoy Jr. The verdict reads as follows. As to count one, violation of the Georgia Street Gang Terrorism and Prevention Act, we, the jury, find the defendant guilty. As to count two, violation of the Georgia Street Gang Terrorism and Prevention Act, we, the jury, find the defendant guilty. As to count three, murder, we, the jury, find the defendant guilty. As to count four, we, the jury, find the defendant guilty. As to count five, felony murder, aggravated assault, we, the jury, find the defendant guilty. As to count six, felony murder, aggravated assault, we, the jury, find the defendant guilty. As to count seven, felony murder, criminal damage to property, we, the jury, find the defendant guilty. As to count eight, felony murder, possession of a firearm by a convicted felon, we, the jury, find the defendant guilty. As to count nine, felony murder, possession of a firearm by a convicted felon, we, the jury, find the defendant guilty. As to count 10, felony murder, possession of a firearm by a convicted felon, we, the jury, find the defendant guilty. As to count 11, felony murder, possession of a firearm by a convicted felon, we, the jury, find the defendant guilty. As to count 12, aggravated assault, we, the jury, find the defendant guilty. As to count 13, aggravated assault, we, the jury, find the defendant guilty. As to count 14, criminal damage to property in the first degree, we, the jury, find the defendant guilty. As to count 15, possession of a firearm during the commission of a felony, we, the jury, find the defendant guilty. As to count 16, possession of a firearm by a convicted felon, we, the jury, find the defendant guilty. As to count 17, possession of a firearm by a convicted felon, we, the jury, find the defendant guilty.
All right, ma'am, if you could hand that verdict form back to Deputy Scott. And I'll make that available for counsel to inspect and ask if there are any objections to the form of the verdict.
None from the state.
Any from the defense?
No, Your Honor.
Anything further required of the jury at this time on behalf of the state?
Your Honor.
I'd ask that the jury be polled, Judge, before the.
All right, members of the jury, at this time, I'm going to call on you each individually by juror number. And I have 3 questions to ask each of you of whether that was your verdict, whether it was freely and voluntarily made, and whether it's still your verdict. So beginning with juror number 3, if you could just raise your hand. All right. Was juror number 3, was that your verdict in the verdict room? Was it freely and voluntarily made by you? And is it still your verdict? Juror number 4, was that your verdict in the jury room?
Yes.
Was it freely and voluntarily made by you?
Yes.
And is it still your verdict? Juror number 8, was that your verdict in the jury room? Was it freely and voluntarily made by you? And is it still your verdict? Juror number 11, was that your verdict in the jury room? Was it freely and voluntarily made by you? And is it still your verdict? Juror number 15. All right. And was that your verdict in the jury room? Was it freely and voluntarily made by you? And is it still your verdict? Juror number 16. Was that your verdict in the jury room? Was it freely and voluntarily made by you? And is it still your verdict? Juror number 28. Was that your verdict in the jury room? Was it freely and voluntarily made by you? And is it still your verdict? Juror number 29. Was that your verdict in the jury room? Is it freely and voluntarily made by you? And is it still your verdict? Juror number 33. Was that your verdict in the jury room? Was it freely and voluntarily made by you? And is it still your verdict? Juror number 34. Was that your verdict in the jury room? Was it freely and voluntarily made by you? And is it still your verdict? Juror number 40. Was that your verdict in the jury room? Was it freely and voluntarily made by you? And is it still your verdict? Juror number 43. Was that your verdict in the jury room? Was it freely and voluntarily made by you? And is it still your verdict? All right, members of the jury, at this time, this concludes your service as jurors for our county. all the obligations and restrictions that I placed upon you are lifted. So if there's anyone that you want to discuss this case with, you're certainly free to do that. But you're obviously not obligated to either. And in just a moment, I'm going to come back and be able to thank you. I want to thank you individually just for the service you've performed as well. And oftentimes, I know that counsel want the opportunity to speak with you to get any feedback that you might have for them on how they handled this case, or to answer any questions that you may have for them as well. But again, certainly you're not obligated to do that either. But it is with the thanks of the court for your service this week that you are now dismissed. Thank you so much.
Rise for the jury.
If 30 days.
Did either counsel wish to confer with the jury if they're open to it?
Yes.
Mr. Cowan?
Not opposed to it, Judge.
All right, I will go and meet with them. We'll be in recess. And the expectation is that we would begin with any sentencing hearing in about 30 minutes or so. We're in recess and off the record.
State. During.
Yes.
Hold them in here. You want to take, where do you want to take them?
I just want to take the people that I need to have for victim impact statements into account. Just to have a quick conversation before we start. Is that okay? At least one. So large. Yeah.
He's gonna go in this.
You'll stand by. Yeah, he said this. No, it's open. Oh, I hear almost every.
I know. Good job.
No, good job too.
Sorry.
This was really interesting. And I learned a lot from you, so thank you.
Well, you've probably.
That's what I'm about to.
That's like pictures too.
Yeah. I appreciate you, Mr. Curl.
Thank you so much.
Yes.
Exactly. You know, so. You don't get that, right? So. Yeah.
I'm sorry.
Oh, that's
I brought them
all
out
of
for
them?
you. Yeah, that's
That's
it.
everything?
Yeah,
I was looking at the thing.
yeah. I just sent them there.
Oh. Oh.
Can't be scared of them. Hey, bro, that was seafood. Right. I'm asking you this, man. Hey, my man. When I get to the making, you do it. Just at the same. It'd be crazy. Probation lady be acting like she be doing something. She over there with it.
Oh, hush. Oh, hush.
You know, I ain't seen you in a couple of weeks, so I had to get you before you got me.
Oh, hush.
Got a computer open, don't say like she.
I'm doing the work.
Right, okay, playing.
Have you been working? Ooh.
I was about the 4th quarter when I didn't even get there. High profile too. I've been kind of scared. I was trying to I was there. I'm usually against Moses talking about this shit. Keep that man. He up Jones back. But she was sergeant like that down there. You probably remember her good.
Hey.
I remember that.
Are you still in the office?
Too mean hell too. Jones back might she might watch her age. Might make it leave up.
I'm still in court. We're on a break right now. They just got a verdict for, Linda's trial.
Yeah. Scott over there.
But for what? What was it for?
Tim, I got it. That's a sword. I'm like, very robust. So that's the started a year before he went to jail. That was like, that was when the sergeant did. I probably got at jail. But who did? Same. And I'm not really going out there. I'm back on home every day. Get clear. Or, no, but I hold the I got down at 8. Like that. Okay. You're a bit more. Somebody got down here.
Hey, you don't see flow.
Better talk to her. Yes, but that's let the party talk.
Okay.
You might go back.
Not to review.
Everything.
But,
It's pretty well started, but on that, I ain't sure. Got the, I'll take it. Got the arm. I'm not sure if you go back to the fourth cemetery. Can't remember.
He may have went back to the jail for that. I think that's what I know.
Rob Holiday. Or follow. Oh, yeah, I was in the basement. That's what they have all that name with the.
They want to see me? If you want, if you ain't comfortable, that's all. They ask for it. Thank you. Happy to do it, come on, see you, but I don't know. Okay.
Here. Here, it will turn some happy, and you can put some money. No. I already told the guy, tell me.
Shit, crazy. I don't care what. Oh, man.
If that shit on, because they.
Something. He don't have a radio. Don't even have a radio.
What are you talking about, bro?
Man.
What you talking about? What you talking about, bro?
Dude, man. With reading.
Did defense counsel not want to come?
I just step back out. He
Yeah,
went out
step
the
back
hallway.
out.
Step out?
Yeah.
Okay.
Was hard. Sorry, more.
Yeah.
Sorry, no more.
Go, dude, what man?
Too comfortable, brother. They don't do shit. You got this shit on, bro. Just that I don't like, you know, a certain breaker ain't got it. Then when they shoot it, oh, they don't shoot you, you get mad. Why they get hurt? It's top.
Man, listen.
Flush your head right over, bro.
I don't like it.
Ain't nobody saying nothing to them, they don't care.
Every time you can see, boy, just look out.
I'll tell you. That shit is on your visit.
Now you wear your fist.
Yeah, no better than that.
He has no bill. Just got his gun.
Put everything on the auto, on the triangle belt.
No, not everything, just a gun.
That's stupid.
I'm like,
Even
come on.
yesterday, I just put my auto carrier on. You know what I'm saying? I could, if I'm not gonna put no belt on, I can put my mask on my chest. You know what I mean?
Have your mask, have your handcuffs. You can't help me, man.
Right.
Well, like I said, he does waive it.
Oh, you want our kids wrong. No, very, no matter.
That
You just want to, right, with it, and doing this up there.
one call a guy.
They gonna have Huh?
One, okay,
How many back there?
he's talking to somebody else.
Who's it? They waiting.
But three more.
Three,
Three more he gotta talk to.
then they all go.
I don't know.
Then your people, then your people else that.
Gay's done, Gay's done.
He not, he went out.
No, he ain't there.
I'm gonna let them know he ready.
Is them your people?
Oh.
You people in back here.
Yeah, everybody, all of them.
If they see them for our shit, we can get the fuck around down.
They waiting on Gay,
The one that can go down is he in a separate track.
Grayson, they waiting on. I'm sitting at him.
He's not in the back talking to his client.
No, he didn't go in the back.
No, he don't, he said.
Don't want.
Hey, Gay is finished. I said Gay is finished. This is Laura. Yeah, he finished the game. Yeah. Okay.
Do the law library in the courthouse anymore?
Courthouse.
Is, where was it, eighth floor?
Eighth floor.
Is that the regular law library?
What's the seventh floor, what?
Oh, I don't know anything about that.
There's a law library here for,
I forgot what floor.
they kind of took all the books out, it's all just like automated now.
You need it.
Well, I was wondering if it's like one with a copy machine in it.
Right, you can go to the what's name? You get a copy machine?
Mhm.
Go to the seventh floor, so you got that, Justice Resource Center. Go to the
Which
seventh
resource
floor.
center? Okay.
So you're up on the seventh floor?
Yes,
Make sure
straight
you
ahead.
walk straight ahead, right there.
Thank you.
Yeah, you can probably sit in the back, they'll probably do it for you.
What do you mean?
See what I mean?
It's a few things I need to do, I'm just, gotta,
The Justice Resource Center, they do
okay, seventh floor.
it, yeah.
All right.
I'm so sorry, man. I know. I gotta tell her. I gotta tell her. I said, no, I'm not even sure. I got one too. I see you get out of court and they feel the purpose shit back here. Yo, the phone to. Okay. So it's gonna be a lot of things. You always gotta get low. You might be in the front part all down. She don't know, I think she always did. I think so. See, right, wait, wow. She fucking proud of that. That's sort of. I'm trying to figure out how you folk get the ball. For a very long time. Now, this you know. Anything around, I can say it, John. Now, with opiate, production, bad time. The folks say, you're not going to the jail. Or that was enough. But then on the next year, I can't wait for shit. It's I'm going to court. I'm going to jail. Hopefully, it's going to be court. Hopefully, Paul's been here. I'll probably been over there. We don't know about what you did.
Well, Mr. Coyne, they were looking for you.
Oh, really? I asked them if they asked me specifically and
Oh, you said what?
I told him he's good.
Oh, you didn't want to.
well, I mean, they didn't ask for me specifically. That's what I.
Yeah, but they will ask where's, well, somebody asked where's Mr. Cohen? And they was like, he wasn't out there.
They thought that he don't know that he could have the opportunity to go back to speak for.
Yeah, he said he wanted, yeah.
No, he said he was good.
I'm acting like his attorney. I'm sorry.
If they wanted to see me, I was fine with it, but I don't think anybody asked specifically for me. You know?
Okay.
They want to be the probation too. They be sitting there looking at her.
He's so high.
Probation.
I'm tired of you.
What can I-
So
what
they
can I
still talking
possibly
if
do?
you want to go back there, Mr. Powell.
I'm not- I don't want to relive this whole thing.
Aw.
First time was fine. Good enough.
Probation, they want you back there.
No,
I'm good. All week and they didn't know what's going on.
Whatever.
All I gotta do is wear a suit. I can't look cute as you, but I can wear a suit.
So aggravating.
We'll see that one. My cousin been coming down there, a bunch of them too. Oh, bro. My nephew. Which guys they got? Oh, that's gonna have it.
Less, Starks?
Yeah.
Yeah. He, even though he ain't want to go.
Now, Dark's in trouble too. He had me a job the other night. Like, if you want red for. I worked right 2 weeks ago for him. Gotta be driving. Traffic.
You trying to stop traffic on your side. They don't know what that is, you know, bro. Even if you ride a bike, like, you gotta stop.
Man, they got this street with over hands up there.
Like this.
Yeah, I got my lights on.
He don't listen, but still, they couldn't see him. They don't know.
Lights in the palms.
You got, he had his vest on. But they can't see your hands.
Yeah, you had that shit lit up on your shoulder, but that light.
But we, they like, but still,
Damn, you gonna see me out here.
I do this. But you fall back, they made back there, I do this, hold my hands up and go like this. So when they see that, they're not bring my hands down like stop for me. You know? That's how.
And you big, so.
You ain't gonna be doing.
I'm gonna horn one
You
side.
ain't gonna be- and then he
Put my
did
hand
this.
up.
He did this, and now that he did that, he didn't wait till they stopped, he turned it back. I'm like, man.
That's how everyone got hit. They hit him in front of the church. You wasn't out there yet. When he hit him from
Don't be
the,
paying attention.
from right there. Smack him.
You better get ready to bail out, man. Get out that, get out the road, get out the road.
I ain't about to hit by no car, bro.
Like that whole national. I don't look at traffic out there too, flag got here. You know what I mean? What the flag, you know, they got everything on visible, got ran on.
So the folks don't care.
And what's going on? I'm sorry, I wasn't paying attention, I was on my phone, they admit, cause they, you know what I'm saying?
What you like, you on side Burford's on? All that.
That makes sense.
Remember Burford's the only one who's been all national. The rest of it should be on Bird.
Yeah, I'm on national.
Top gate.
What you had down there?
No, I mean,
Down there,
national birthday. Other side though, the middle of all that. So when they used to come out the other side, we gonna get it in.
No, I'm in the middle of the street. I'm at the intersection.
Walking like she knows where she's going. I was going back there with you. That's probably where I need to be. Want to ask her back or? I'm doing wait. I'm just. Okay. I got it. All right. Okay. Sure.
Excuse me. That's what May said.
I'm gonna take those phones back. Thank you. I like the houses as well. It's good luck.
Cause I keep telling you, we've been taking over.
Oh, we got a friend.
No, not him.
What do our jurors have to say?
Why you didn't go back there?
They didn't ask for me.
They-
Asked the deputy, I said, do they want me specifically? And he said, no. I said, well, I'll be right. He said,
Well, I don't. Wait a second. He didn't ask for me specifically.
I think they did. They said, we would like to see Miss Green back here.
You sure?
No.
Okay. I don't think they did that. They were just basically saying, giving me feedback on what I could have done better as far as letting them know Manson's PowerPoint's not going back there. So you might wanna mentally or take notes on this gang thing.
I don't think she's that great. I mean, she does explain things the way she.
Yeah, I know. I could tell you didn't think she was that great. What do you think?
How could she?
Yeah, improve, like, what do you mean? She doesn't explain things. Manson, so what, Manson is a wealth of knowledge. Like, she has a ton of knowledge.
She's probably a savant and I just don't realize it.
Hmm?
She's probably a savant and I just don't realize it.
But I think she does a great job. But if I ever need to just know some random fact, that's Manson. Manson knows everything. But yeah, everybody has their own style. They also talked about, you pointing out the missing pieces, like the missing guns, the missing this, the missing that, and then they like the dollar bill reference, we always use that, to show like, okay, sure, it's missing, but you still know what it is. They believed all my witnesses, mostly, except,
Even Mr. May.
yes, yeah. You shouldn't, entertainment only? That man did not want to be here.
Well, you'll be out on the town. You paid for a round trip.
No, sir, as soon as he
Expensive
left here,
patient.
he got back on the plane.
Oh.
He didn't have an overnight stay. He got right back on the plane. But I didn't feel the need to.
He's probably the
address that.
probably the airport lounge, having a few drinks, styling and.
Okay, all right, maybe he was at your spot. But they also, except for Rolo, they didn't believe him, but.
Yeah, who's gonna believe her?
Right. So.
Who they like?
And then I was told
Which
to go
witness did they
into
really?
acting.
Which one did they really like?
Huh?
Which witness did they really like? Vulnerability.
They didn't name a specific. They're gonna watch.
Okay.
They wanna watch sentencing. I encourage them to come out of house. Oh, that's, I know. Probation, I don't think you'll be needed. Oh, yeah, I don't think probation is.
So, Amanda, your recommendation now.
So it's my recommendation, now I'm about to kill the suspense of it all. It's my understanding, but Judge McAfee will correct me if I'm wrong, that it would be life without the possibility of parole plus 65. I could be wrong. I'm not the best at math, but you want me to go through how I got there or?
He's probably gonna want you to.
Yeah. And then I need to enter into the last certified conviction. They have the other two. And this will be the
Are you
fourth.
talking about the Floyd County? You're
Uh,
talking about Floyd County?
yes, Floyd County. Yeah. And then because we didn't go into the details about what these convictions are. I will ask if I can now. But I don't know what value that
He's
serves.
not left with a lot of discretion, really.
Right, no. Look at that. Thank you, Keelan. Thank you, Keelan.
Yeah. He said he's 6 feet out. I might count.
An internship.
You're not facing anything next week, are you?
Oh, yes.
Amanda, you're not facing anything next week, are you?
Yes, I have to go into another trial, but at least it's not homicide. At least it's not homicide.
It's refreshing.
Huh? Okay.
It's refreshing.
Yeah.
Whose courtroom?
Kraus.
Oh, she's great.
Okay. Okay.
You know why she's so great?
Sorry?
You know why she's so great?
You know why? Who's so great?
It's Kraus.
Why?
Mercer graduate.
Confirmation.
But she's a Mercer graduate.
You ready for it right now? Let me check in with the parties. Ms. Green, do you anticipate any victim impact testimony?
Yes.
All right, and how many?
Did you say how many?
Yeah.
8.
All right, I think we will have to
Narrow
impose
it
some
down.
limitations. No, you don't have to narrow the numbers. I'm just saying, I don't think we can make it open-ended because we still do have some other folks waiting for their plea and arraignment dates. I think we have several pleas we still have to get through as
Can you put
well.
the time clock on?
You know,
I would
you know, I
pick
wouldn't hesitate, but
Okay, so
if you
what
could
would
just advise them to limit it to a few minutes each.
Okay, can I make the outside of the mother and the direct, let there go a little bit longer and just tell everybody else, the other 5, to make it short and sweet?
That's fine.
Okay, I'll do that. Oh, you're here. Did you hear me? I heard. Okay, so, sister. Okay, thank you guys. Ms. Williams, or the officer? Everybody else, if we could just use. 3 minutes, okay?
Look, and I typically wouldn't say anything. I think just in large part, since it's my understanding, based on the evidence and aggravation you're going to present, there isn't really much to decide when it comes to sentencing. But I certainly want to give everyone their right and ability to speak their piece. So I'll just say, if they can just be mindful, since there are so many people who do want to be heard.
Start rubbing it a little bit. Okay.
Mr. Cowan, is there anything, I know there'd been people coming and observing that appeared to be with Mr. McCoy. Was there anyone that he was expecting to present?
No, Your Honor, but I believe they have left.
I'm sorry, I didn't catch that last part.
No, but I believe they've left. I think it's.
They knew that this would be happening today, potentially? Okay. All right, well, then we can bring out Mr. McCoy. Ready? We are back on the record. All parties in council are present, and council have indicated that they are ready to move on to a sentencing hearing, the jury having returned a verdict of guilty on all counts. And so I turn first to the state, and I would ask Ms. Green, from the outset, if you could just tell me the state's recommendation, globally and count by count, and then present any argument or evidence in aggravation that you wish to present.
Yes, Judge, you want me to come to the podium?
Wherever you're comfortable.
Okay. All right. Your Honor, pursuant to the statute, the state has given sufficient notice on the record to the defense prior to the commencement of trial of 3 prior certified convictions, and the state also allowed the defense to inspect those certified convictions prior to the commencement of trial. The state intends on entering State's Exhibit 502, which is the 3rd certified conviction out of Floyd County. The
All right, let me pause you there. Any objection to State's Exhibit 502?
No, you are. Can I see it for a second?
Floyd County.
Yeah, no, you are.
And if you could, Ms. Green, retrieve 502, 501, and 500, just so I can see all 3 of these. Unless you're using those to argue. All right.
And so as the court requested, the state's recommendation is the maximum on all charges. State believes that is life without the possibility of parole plus 65 years. If we was to go through them individually, on count 1, the gang statute, the maximum is 20 years. Count 2, maximum 20 years. Count 3, murder, life without the possibility of parole. Count 4, murder, life without the possibility of parole. Count 5 is life without the possibility of parole, but it would vacate by operation of law, and that is applied to count 5, 6, 7, 8, 9, 10, 11, all the felony murders. Aggravated assault would merge, count 12 of aggravated assault would merge into count 3. Count 13, aggravated assault, it would merge into count 4. Criminal damage to property, while the felony murder vacates, criminal damage to property can be sentenced on, and the maximum to criminal damage to property is 10 years. Possession of a firearm during the commission of a felony, the maximum is 10 years. Possession of a firearm by a convicted felon, the maximum is 10 years. And possession of the firearm by a convicted felon under 133 is 15 years. And it's my understanding that he can be sentenced on the 15-year 133
And so
and
counts,
the during.
so you and counts 15 and 16 merge into count 17.
15 and 16 merges into 17.
All right. And so the state's
15 merges into 17? Okay. Then my number is not the same as yours.
That still equals 65.
It does? Oh, okay. Okay. Yes.
All right.
Do you want?
Yeah, any other evidence, argument?
Yes. In addition to that, Your Honor, while I understand that the prior acts that Mr. McCoy committed did not come into evidence at trial, I believe I can argue them briefly, very briefly, in aggravation evidence. The 2 convictions that I wanted to bring in at trial, well, specifically the one, there's really one, it's the Floyd County conviction. Yes.
Which exhibit would that be?
I believe it's the one I just handed you, the 502. The reason why
that one is the one that I wanted to bring in, is it's trafficking drugs into the Floyd County Prison. When you heard the testimony of Manson, Gangster Disciples, that's where they dominate in the prison system. And McCoy coordinated that act in transporting those drugs. A very layered conspiracy to have the drugs transported to the jail and then those packages removed from a container and then shipped into the jail. He worked with multiple prisoners. He is influential. He does have status. I'll give him that. But that's important. Those pictures showing off in jail, he wasn't a nobody. He's pretty.
Sorry.
Okay.
No,
Okay.
a question on that. On that exhibit, and I forget the number, but that was a phone seized while he's in custody on this case. Did you have a approximate date when you believe that picture was taken?
Of which one?
Of the one from the Fulton County Jail.
It's 2023.
That was from 2023.
I believe so. I don't have the PowerPoint. Oh, it's up here.
Okay, so that was from when he was in custody on some other case.
Has the date on the top. Amanda. And I'm not saying one has to do with the other. I'm just basically saying, oh yeah, May 31st, 2023 is the date.
So what was he in custody for at that time?
I believe in June 3rd, 2023. A Fulton County conviction, Clayton County conviction. Thank you. I believe this was his attorney on that case. So that is really the main transaction that I wanted to bring in. If the court would have denied all those transactions, I really just wanted that Floyd County one. And so that's the only one I wanted to talk about as it relates to Mr. McCoy's influence and status within the gang. And with influence and status, you don't get out of the gang. He will continue to associate himself with the gang and with that commit further crimes. And that's all I have as far as aggravation. And so now I would ask if the state will be allowed to have brief victim impact statements. I know we have 8. I'm going to start with Ms. Kiera Wallace.
Your Honor, my name is Kiara Wallace, and I'm the mother of Riley Houston, the daughter of Joshua Houston. I'm here today not only as a mother, but as someone trying to explain what it means for a child to lose their dad. There's no way to prepare a young child to understand why her dad is never coming home. Every day I see the confusion and pain in Riley's eyes. Since Joshua was taken away from us, our lives has changed completely. The laughter, the support, the love that he brought into our lives is gone. Riley has lost the chance to grow up with her father, to share birthdays, graduations, first days of school, and all the milestones that they should have had together. That loss will never go away. I've had to become both parents, trying to fill an emptiness that no one can replace. Your Honor, I ask that you consider sentencing. I ask that you consider during sentencing that you remember the innocent child that was left behind. Thank you.
Thank you, ma'am. Thank you for being here.
And now Ms. Brianna Cole for Mr. Joshua Houston. And that is BRIANNA Cole, COLE. Kiera was KE. Oh, I'm sorry.
First, I want to say that today isn't about the person who took a life. It's about the one that we lost. We're here because someone's choice changed everything. A choice that stole a friend, a son, and a father. Someone who meant something real to us. I don't want to spend too much time speaking on the person responsible because you already took too much from us. But I do want you to understand your actions didn't just end a few lives. They broke hearts, they changed futures, and they left a hole that can never be filled. We forgive when we can, but we don't forget. And I hope one day you truly feel the weight of what you've done, not just legally, but in your soul. Because taking a life is easy, living with it, understanding it, and facing it, that's where the real punishment is. To my friend, we love you, we miss you, and your name will always mean more than the one who took you from us.
Thank you, ma'am.
And now, Ms. Sherelle Williams, the mother of Mr. Leonard.
Hi, Yana. This is not our first run. You did a case with my other son, my granddaughter, father, Robert Bankston and Cedrica Smith, double homicide. So I went to the same courtroom. It replayed itself the same time because the other young fella, he didn't accept accountability, just like he didn't accept accountability. So God prepared me for that trial because everything is written. And I know that Mr. McCoy, maybe he took my son, but my son didn't. You can't kill you can kill the flesh, but not the spirit. So I want to just say thank you. I thank Fulton County, the jurors. Thank you all. I really appreciate everything. But Corey was not affiliated. He had license to carry guns. The children that he impacted, not even my family, I'm talking about kids that came to my house and said, Uncle Corey, you know, that did something to me. So they let me know that Corey did what he's supposed to do, did while he was here. He served his purpose, you know. Also, I just want to say that when I got on that stand and I had to ask God, because I'm fighting flesh too myself, because I wanted him to be like my son, but God said that was just too easy for him, you know? So I just want to say that at the end of the day, sorry. I asked God to show me if Mr. McCoy really meant to do it. In my heart, he didn't mean to do it. He was going off ego and pride. That's my feeling. That's what my God told me. And why I say that? Because when I looked at him, he could look at me in my eyes. Yeah, he laughed at a lot of them that got on his stand, but he couldn't look at me. So they let me know he has a conscience. And I accept the apology. He ain't got to tell me. God already told me. But I just want to say, it's kids that's been impacted. You know, Corey had 3 kids, and I can look in their eyes and I can see my son identical, look just like him. And I also saw Mr. McCoy child as well. And I just pray that God just bless her with a father that nothing's like him. You know, and the mother don't allow that baby to do the life sentence or whatever charges that would you give him. But I accept it. And I'm at peace. And again, I thank you, jurors. I thank Fulton County. I thank you, Your Honor. Your job well done. That's all I want to say. Thank you all.
Thank you, ma'am.
You want me to do the grandmother?
Yeah, that's Lucille.
Okay, Miss Lucille Williams. No, Lucile Williams. This is the grandmother of Mr. Leonard.
Thank you, Your Honor, for this opportunity. Oh. I just praise and thank God how He kept our family together. And I praise and thank God how I kept him. I raised him and raised him in church. And he used to be my drummer in my church. But God used him to touch other kids and mentor to them. And he loved his kids. He showed them how to respect people. And he would take them on vacations. And I mean, whatever. He was there for his kids, and he showed other kids, and plus he was a mentor to other kids. And I just thank God that he didn't die in vain. And I just thank God. I prayed and I asked God. I asked him, I said, Lord, he have taken 4 lives is gone. Mr. Houston and Corey. Corey, 3 kids. And the 13-year-old, he's having some of the problems. The 3, the 5, and the 7, they still ask questions to their mom, and they haven't gotten over it. Then I think about Mr. McCoy. His life is gone, and his daughter is gone. But I said, Lord, I forgive him. But I asked the Lord to use him in the present, that he would turn his life and repent to God, and that he would mentor or talk to others, spread the word, God's word, where others in there can be saved. And that's all I have to say. Thank you.
Thank you, ma'am.
The sister. All right, and now, Tanika Thrift.
Go ahead.
Is that not right?
Yeah.
Okay, and that's TANEKATHRIFT. TANIKA. I apologize. You can come on.
Good afternoon, Your Honor. My name is Tanika Thrift, and I'm Corey's oldest sister. Even if I could address Anthony for taking the life of my brother, I wouldn't, because, Your Honor, I think we have given too much of our time. So I'll address the courts and my family. In one of the evidence videos where the defendant was being little man, as DA Green put it, if you can hear my brother, you can hear my brother asking the defendant and Polo to stop. He kept saying, y'all stop, man, y'all stop, man. You can also see him gesturing at them to stop. If you knew Corey, you knew that voice from anywhere. He didn't keep up a lot of mess. He stayed out of the way. He was a cool little brother. He was just a fun guy. He wasn't in a gang, but he had a gang of friends. His family were all hurt, but the deepest hurt, like his mom said, are in the children. His kids miss their daddy. My kids miss their Uncle Corey. My nieces and nephew miss their Uncle Corey. My little sister misses her big brother. He was a kid at heart anytime he was around them. He had a soft spot for his 4 sisters, and we had a soft spot for him. He was taken from us, and we will never be the same. My favorite picture of my brother, he's in Jamaica holding a glass of his favorite drink, and we all know what that is. He's holding it up as he's giving a toast. Today, I'd like to think he's giving that toast to the jurors for sitting here for a week for him and in honor of his friend Polo. I'd also like to think that he's given that toast to DA Green for fighting on his behalf and for taking her time to research and solve this case for his family. I'd like to think that he's given that toast to all of the witnesses, even the ones who didn't want to speak up. We knew what you meant without you even saying it. And a toast to Detective Principe for doing what he said and bringing this on home like he promised. And I'd like to think he's given that toast to you, Your Honor, for upholding the law and handing down the maximum, most appropriate sentence for Corey and Joshua's murder. My family also thanks you all and know that you guys will make the right and only choice there is. Thank you.
Brother. And then Welton Beck is WELTON BEX, and that is this younger brother of Mr. Leonard.
I ain't gonna lie, I just had adrenaline walking up here. What's up, Judge? All right, boom. Yes. All right, my brother, he's a love guy. I ain't gonna lie. I made a promise I ain't gonna come up here and cry because that's what my brother was. He a man. He stood up first. You know how I feel to lose your dad in 2021 and your big brother, the father figure, and he passed? Now, you gotta try your best to be that father figure to his son, the 13-year-old one and the 5-year-old one. It's hard. But I got courage. I'm gonna stand up here today and I'm gonna talk about my brother. My brother, he's the GOAT, man. He Corey, he Dan, you know? I find it crazy that I gotta stand up here and wear this necklace of his body, wear the jury while I had to clean off his blood so he can wear it at his funeral and I can wear it on my wrist. Where I gotta have this tattoo on my brother date and death date. See what I'm saying? but I'm gonna be that guy to lift my head up and show y'all I'm strong. And Teasy,
Nope. Nope.
I forgive you.
Don't look back.
Don't
Look at the
look
judge.
forward.
Look at the judge.
I had to let him know that I'm a man. Cause that's what I'm forced to be. And that's okay. Cause that's what's God planned. Y'all keep y'all head up. It's okay. My brother was love. He's dang, he used to go. I just can't express it anymore. Adrenaline rushing, so I really can't say everything I want to say, but I know y'all feel it's pure. Thank you, Jerry. I really appreciate y'all. Thank y'all, Court. Can you give me a hug?
You did a great job.
I love all y'all, man. Keep y'all head up. Keep God first.
Thank you, sir.
All right, Your Honor, I'm almost done. I have, where did my picture go? I have Miss Portia Harris. That's PORSHEHARRIS, and that is the fiance of Mr. Leonard. And I think that's everyone, isn't it?
Portia, can you,
Okay.
let me see.
Hello, Miss.
Good afternoon, everyone. I want to say thank you to all the counsel in the room. Thank you, jurors, for your decision. Corey proposed to me in front of thousands of people on the stage. I never got a chance to wear my dress to my wedding. I wore a white dress to my funeral, his funeral. He took a part of my life that I'll never get back. Corey was a good man. He was a hardworking man, and he loved God. We went to church. We made it our business to go to church every Sunday. I don't care what we did over the weekend, as far as having fun with ourselves and our children. We have 6 children blended. 3 is his and 3 are mine. I have children that are being impacted by this right now. All 6 of our kids are going through things right now because he's gone. I have a child that has thought about leaving this world since he been gone. I suffer from PTSD since he been gone. He brought me back to Christ. He loved God and he loved to have a good time. He was a hardworking man. He worked a full-time job and also had his own job on the side. Corey was a blessing to me. And he always told me to hold my head up. So moving forward, I have to hold my head up and keep living life and still check on his 3 children. And I still have to mother my 3 children. I love him with all my heart. And I also love his family as well. This has totally affected me. I'm very unstable. We lived together for 3 years. I breathed and ate with this man for 3 years. My finances and everything. I'm just trying to figure out life again and how to rebuild because I have been totally unstable this last year and a half. Thank y'all so much once again. And I have nothing to say to someone. I have nothing to say to no one else in this room.
Thank you, ma'am.
And that would conclude the victim impact statements, Your Honor.
Anything further on the part of the state?
Nothing else for the state.
Mr. Cowan?
What's it? Your Honor, I realize that the court's left with very little discretion in this matter when it comes to sentencing. We, just for the courts, so the court will know, Anthony has 5 children between the ages of 1 year old and 12. He actually was employed, and I know this employed During the time that I knew him, and since 2021 or so, worked for a construction company. He was a machine operator. He could have continued to do that, I'm sure. He's 32 years old now. He graduated from Riverdale High School in 2011, I believe. His mom was here during most of the trial. She's heartbroken. I know some of his siblings were here, and I understand his father was here, although I didn't see him. It's a bleak and long sentence, no matter what, bleak prospects for my client. I'd ask the court to exercise any discretion that the court can, but of course, we understand that that's limited.
All right. Thank you, Mr. Cowan, and thank you, counsel, for the work you both have put into this case. Just first say and thank those here in the gallery in attendance for this trial on both sides, including those that are no longer here. And clearly it showed that this is an important case in all aspects, and the stakes are so high. And I want to express my sympathies to the family, and it's very clear to me that that your loss is not one that this trial can ever replace. But what I can hope is that seeing this process through allows you to begin that process of closure, to put this behind you and to start focusing on the things that really matter. Your focus can now be on the memories and those moments that you described and are special to you, and not on the unpleasantness you had to endure throughout this trial. But I don't have too much else to add here. I think both the nature of the case here as presented by this case, by the state's case, and the evidence show just a general callousness, a disregard to human life. I think that same attitude has been expressed here in trial. I don't think there's been any real appreciation of the harm, the loss that's happened here on the part of Mr. McCoy. And I think his entire life so far is evidenced through the state's evidence of aggravation, these prior felony convictions, how he conducts himself in the jail, and just generally what he has shown is important to him in this life. Do not give me any confidence that he deserves any mercy from this court. And so although the sentence is compelled by his prior felony convictions, I'll just state as a finding for the record that I would impose the same sentence regardless. And that sentence would be accepting the recommendation of the state. The sentence as pronounced will be on count 1, 20 years to serve. That will be consecutive to count 3. Count 2 will be 20 years to serve, consecutive to count 1. Count 3 to the charge of murder, the sentence is life without the possibility of parole. Count 4 is the same sentence to run concurrent to count 3. Counts 5 through 11 vacate by operation of law. Counts 12 merges to count 3. Count 13 merges to count 4. Count 14 is 10 years to serve. That'll be concurrent to count 3. Count 15 and 16 merge into count 17. And 17 is 15 years, again, required to be consecutive. That is consecutive to count 2 for a total sentence of life plus 65 years. And Mr. McCoy, I have to advise you that you have the right to seek post-judgment relief from your conviction of these crimes by either making a motion for new trial in this court or by filing an appeal to a higher appellate court. If you want to file a motion for new trial or an appeal, then you'll need to file that with the Clerk of Superior Court of this county within 30 days. You'll want to discuss this more with your attorney. If a motion for new trial is made and I deny it, then you'll have 30 days from the filing of that order of denial in which you can file with the Clerk of Court your notice of appeal. You have a right to have an attorney represent you on the motion for new trial and the first level of direct appellate review. And if you cannot afford and hire an attorney, the court will provide you an attorney and a transcript of this trial at no cost. These all being felony convictions, you have a period of 4 years from the date the sentence is finalized and to file a habeas corpus petition challenging those convictions. Is there anything further to be put into the record on behalf of the state at this time?
No, Your Honor.
Anything on behalf of the defense?
No, Judge.
All right, this matter is now adjourned. Thank you all.
Enjoy your weekend.
You too.
Bye.
Ms. Smith?
Well.
No, some of those are exhibits. What's that? I don't think his people stuck around.
Ms. Ortiz, I got your paperwork. I brought it back.
I didn't have time to go back to the car. Can I? What do you want me to do? If I can find it, you want me to destroy it or send it back to you?
I can take that. Okay.
Well, you've got everything except this, right? Everything except that. Okay.
Okay.
I'm assuming it's in one of my files that I do have in the car. Okay, let me hustle down there and see if I can find it. I don't remember the circumstances about whether I left anything on the table or not. I wouldn't think so. He didn't, he didn't have no bag. They didn't give him one. So I don't think so. I mean, I had it, so. Give me about, how long you gonna be here?
It was Bankston. Bankston and Smith.
I know
that's
Robert
right.
Bankston.
Yeah.
Oh,
yeah.
God. Oh, okay. That was my granddaughter. That was her father. Yeah.
He just handled his trial and it's, oh, I'm sorry, we had. That's.
I know,
That case now goes.
Okay.
At the Georgia Supreme Court.
Okay.
What that mean? He filed a notice of appeal, which is a process.
Oh,
And it goes up there.
okay. We not worried. Thank you, Yana.
She said you had to make copies or something?
Can I have a break, Judge?
We're done. Thank you. But I mean. Yeah, that's what she.
We don't have anything else.
Okay.
I have you two now.
I do have Michael Jowers. That's why I'm asking for a break.
That starts back at the beginning.
Okay, all right.
She, getting her.
I'm just thinking.
I thought you wanted me to photocopy them.
Yeah.
You don't trust me, I see.
No, I do.
I
But
see.
this is easier because I tried doing it back there
Mhm.
and it wouldn't